He? Mr. Banerjee, I can see this is regarding the 3:30 fixed matter. Rampur, Ramsharup or whatever. There's an administrative committee meeting which I'll have to attend at 3:30.
Oh.
So therefore we'll have to rise at 3:20.
I'll not inform
please inform, yes, yes, so that you don't wait for that matter.
We'll do that.
And we'll try to date the. I didn't know this when we fixed up the time.
Yes,
meeting time was fixed subsequently.
But I think that has priority than Mulad.
It's important.
Yes, Mulad, sure.
Kakachi. 19th, Mr. Banerjee?
Yes,
Tuesday?
Yes, it should be all right, Mulad. I'll also kindly Mulad put it.
Other side, nobody is there, perhaps.
We are submitting.
We'll block 19th.
Yes.
19th, I'll fellow.
At 3:30, Mulad.
3:30. Yes.
May I have your kind leave to my lord?
Yes, Mr. Ganguly.
Yes, my lord. Mention a matter, my lord. Leave
for leave to file without certified copy. Yes, when was the order passed?
2nd July, my lord.
When did you apply?
My lord, 1st August, my lord.
Why?
There was some delay, my lord, on my part, my lord. Kindly, my lord, consider some urgency. I'm grateful, my lord. Grateful.
Lordship, may I permit to mention a contempt application?
Bench.
Lordship, my lord Justice and the Honorable Justice Murali Dharan.
Yes. Hey, it's the other. He could have it.
It ordered. It ordered. Lodge. Original set. So this is the original side mentioning, my lord. What happens, my lord, an order was passed by my lord Justice Banerjee and my lord Justice Apurva Sinha in the year 2023. My lord, I have filed a modification application, my lord.
Give it when that bench sits, it will be listed. Give them the particulars. It's called the list. Now, we want to say something before you start. What will you say again? You made your submission yesterday.
My lord, some orders, my lord, which are already...
The same. The brothers, they are brothers, the two. Anyway, they are branches of the same family. They were carrying on business jointly in perfect harmony till a point of time. Then they fell apart over property disputes. But then again, good sense prevailed. Before arbitration could take off,
yes,
they arrived at a settlement.
Based on which the consent award
was passed. Now, regarding enforcement of the consent award, disputes have arisen. This is the fittest possible case for mediation.
It has failed, actually.
Sorry?
It has actually, it has. I'm told I am a new person.
Have they tried mediation? Formal mediation, not with friends.
No.
But actually,
Mr. Banerjee, please, we would request you. We are in the middle of this drive called Mediation for the Nation, 90 days.
Well,
it's a
everywhere else.
Yes.
But I've seen there's a strong drive for mediation everywhere else.
That is why my learned friend.
No, I don't want. I wanted to argue the matter. I'm sorry, I just stepped out to try and inform Mr.
Any open for argument today. It was
yes. No, I wanted some.
So mediation you will not even try. Both of you. That's the same.
But
we are agreeable.
Yes.
Mr. Sen, how long will your
Well,
clients live? 100 years?
Convince my client.
100 years?
But only
let them live in harmony. If it can be done, and we are very hopeful, this kind of matters, between family members,
Yes.
But it's only, I'll tell you, Your
Property
Lordship,
is not the most important thing in life.
my lord, actually what has happened, my lord, if the dispute was just had arisen, but over the years, because of the dispute, the relationship has gone
Mr.
astray.
Sen, what we are trying to do to arrest that, the increase in acrimony. If through mediation it gets settled, things will be so good for everybody, for both the groups.
But I understand, my lord. I don't usually.
We feel it is worth giving it a shot.
But,
Now, after that, if the parties say, no, sorry, unfortunately, we can't force you.
We
my
are,
lord, I have to come back, but I cannot
we
take
are
a decision
I think
standing
it's
here.
my lord, if it is possible, my lord, this family has been fighting, my lord, for quite some
But I don't, my lord, I don't say this because why we have been.
Vitan, what
Lord,
does a
it's-
mediator do? What does he do? He facilitates.
correct. My lord, this is a consent award. My lord,
Yes.
there are, my lord, obligations which we said, my lord,
If they
on
could
both
settle,
parties.
if they could settle the disputes at
Yes,
one
yes.
point of time, why can't they do it now again?
The consent award, my
I'll
lord,
tell
which
you
we are
that's
trying
why,
to have it.
I'll try to explain why, my lord. At that stage, it's a question of division. Now the question is, you are already enjoying the fruits and you are not giving it to me. So I have been hit back hard.
Understand,
No, that's
Mr.
the-
Sen?
I have been hit.
I have a
hard.
country submission, so that's what will be sorted out.
When will you come back with the instruction?
Tomorrow itself,
Tomorrow? Come back tomorrow.
because my junior was there in the matter throughout.
Mr. Sen,
I have been-
you are a senior counsel. Try to exert your authority. We request you.
No,
We don't say anything more, but try to.
I shall definitely, my lord, your lordship's observation, I will definitely try. But I don't know whether I will be there tomorrow.
No, quite right. But
I will try. Since your lordship is saying, I will try.
yes,
Let us come back tomorrow at the same position.
this, according to us, this is a matter which can be settled through mediation.
Once relationship
now, my lord, I
gets
don't know, my lord,
soured,
mediation center, my lord, we have a
then, my lord,
lot
it is not-
mediators now, my lord.
Yes, we have a panel of mediators. I appoint mediators every day.
Oh, my lord, I remember, my lord, before, my lord, we
No,
didn't have such a mediation center,
they're
my lord. which
trained
would have-
mediators, and we are getting very good result.
No, that we know, my lord. It has been going
I'm
on
not,
for
my lord.
quite some time, my lord. Persons have been.
Mr.
trained.
Jishnu Shah is a trained mediator.
Yes.
That
For example, Mr. Probal Mukherjee is a trained mediator.
I was not aware, my lord.
So we'll appoint an appropriate mediator if they agree.
Very well.
But only difficulty, I'll tell you, I'll express my difficulty, my lord. Point is,
Yes.
as your lordship saw on the last occasion while hearing the matter, they are in possession of virtually everything. I could have understood some things have already come to me. We are at a level playing field.
That's there.
In the mediation, things might change.
I
who
shall
knows?
give your lordship's observation.
If the mediation works, you will again live in harmony, which is so much better for everybody concerned.
Consent award passed.
It has, well,
Both parties are in execution. I also want execution of the award. My learned friend also wants execution of the award.
No, they have already said no.
Initially, my lord, they resisted, my lord.
But tomorrow, let the client say no, one by one on writing.
ও সব ডকুমেন্ট নিয়ে নিয়েছে এটা করে 6 মাস নষ্ট করবে
But then I will come back instruction.
We already have instructions.
Register kache documents.
Documents.
No,
Then we'll hear him. Why?
I'll come back. But
Your junior has already obtained instructions. We understand a lot of things sitting here, Mr. Sen.
no, it's but
Yeah.
question is
Come back tomorrow then. Come back
My
tomorrow.
lord, only one request. My lord, I have to leave court for personal reasons 11:30.
Today,
No, tomorrow, my lord.
10:30 থাকে
Tomorrow, my lord,
10:30.
at 11:30. So, my lord, I would also, my lord, like to make, my lord, a very few submissions. I know, my lord, has...
সাবমিশনটা এই জায়গাটা তো কালকে পড়ে নিয়েছে
No, my lord, submissions haven't been closed.
Yes.
Mr. Dashgupta, I'm so sorry.
Yes, we will
No.
but is
My
it
little
twice,
lord.
my lord, twice this is happening.
this has happened
But first, Mr. Dhiren Sharma concluded submission.
এন্টার 2 ঘন্টা
ঠিক
কমপ্লিট
আছে এটার পর শুনবো ওটা এটা প্রথম
Am I
10:30
বলতে
থাকবে
চাইছো না?
Yes.
বললামটা টাইম নিয়ে গেছে
Twice, my lord, this is happening. Your lordship will recall, in the month of June, Mr. Dhiren Sharma concluded submission. Thereafter, again,
Mr. Sen, yesterday when Mr. Banerjee came after Ms. Sengupta, am I right?
Mukhopadhyay.
Mukhopadhyay, Mr. Mukhopadhyay, Ms. Mukhopadhyay finished. We had expressed our mind. Your junior was here. Mr. Banerjee said, give me a little time if I can change your mind. So we said, fine.
I'm so sorry, my lord. I was actually, my lord, addressing, my lord, court for. That's the only reason.
That's
my lord, I
all.
couldn't. In fact, my lord, I
10:30
requested
tomorrow, I'll just
No, that-
come with
Lord, if
my
Tomorrow 10:30.
instructions, my lord.
tomorrow 10:30, my lord, I'll be here. But my lord, if my lord wants to hear me, then I don't mind, my lord. If it starts at 10:30, I'll make my submission.
Or you can keep it on Monday. We can keep it on
Whatever's
Monday.
convenient.
No. We can keep it tomorrow.
Lord,
on
I hope, my
Monday.
lord, it is because I'm quite ready to argue today. I hope my learned friend actually takes instructions on this because my lord, I will impress upon my clients that, my lord, if they can settle this, both have execution applications. I accuse him of sitting on my property. He accuses me of sitting on my property, on his property.
এটা তো ওইটা
That's what-
Let my learned
That's the
friend
whole thing.
by an email today
Three
evening,
courts.
give me a list which property I am sitting.
No, Mr.
Then-
Singh.
In fact,
I
Jodhpur
will-
property is the one I'm resisting.
They will do, you will do everything, they will do everything. First, you have to agree on mediation. Otherwise, I will not ask either of you to do anything.
Then, my lord, one condition has to be put, my lord. One property, 4 years, they were given a leeway to continue.
Mr. Sen, we are only on whether your client is agreeable to try out mediation.
No, I shall come back. I shall
Nothing
come.
more.
I shall come.
If they are, we'll pass appropriate order. If they don't agree, we'll pass appropriate order after hearing the parties.
ভালোভাবে আমরা বলেছি
Then, my lord, one line
Online
that
tomorrow.
it has come from your lordship
Yes.
that the
YouTube recording is there. দেখো করে দিচ্ছি।
মানডে না কালকে মানডে নয়
The two branches of the family were carrying on business jointly in perfect harmony till a point of time. Stop. Then they fell apart, obviously over property issues. Stop. However, good sense prevailed, and before the proposed arbitration could take off OFF, the two groups settled their disputes amicably. Stop. They agreed on the division of the properties and businesses. Stop. The terms of settlement also provided for the modalities of the division of the properties and businesses. Stop. Paragraph. Unfortunately, disputes have again arisen between the two groups regarding implementation of the consent award. Consent award that was passed by the arbitral tribunal. Stop. We are of the considered view that this is a case which is eminently capable of being settled through the alternative dispute redressal mechanism of mediation, and that should be done instead of fighting long court litigations. Stop. If the mediation succeeds, which we hope it will, the two branches can again live in perfect harmony. Paragraph. Mr. Banerjee, shall we record your consent, or you want to?
Yes,
Mr. Banerjee, learned senior advocate, appearing for the which group?
follow the
Suresh.
appellate, my lord.
Madanlal Jain group says that his clients are agreeable to try out mediation. Stop. Paragraph. Mr. Shakoshen, learned senior counsel appearing for the Suresh Jain group, seeks a day's time to obtain instruction. Paragraph lists the matter once again, Calcutta date though, marked 10:30 a.m. Stop. This matter will be taken up first, irrespective of whether or not other matters have also been directed to be heard at 10:30 a.m. No, maybe 3-4 matters is
I'm
And
so
this
grateful.
was necessary. Your lordship will find in an earlier round, Mr. Dasgupta's consent was recorded. And he had thereafter they had to file an application for expunging that consent.
I see. No, no, go and tell it, ask them. But try to impress upon them.
I hope, my lord, I'm
এইটা একটু শুনুন না।
Lord, I have not obtained instruction, but I think, my lord, I can impress upon my client. So, my lord, I'll. Other jurisdiction, my lord, I'm seeing this. My lord, there's a lot of, my lord, mediation, and I'm told, my lord, the Delhi Mediation Council actually very strong and very, my lord, successful.
We recently had an all India meeting organized by at the instance of MCPC, the Mediation and Conciliation
Yes.
Project Committee, which is headed by Honorable Justice Surya Kant at the moment. Justice Kant was there, Justice Vikram Nath, Justice Vishwanathan, Justice Dotto, Justice Bagchi, all there. I, being the president of the mediation committee, I was there in Calcutta. Justice Sen was there as the executive chairperson of the State Legal Service Authority and our Chief Justice. So we were seeing other states, the statistics, the figures that we are far behind. So we have to make a drive, and it really is going to help everybody. So now on a case. Yes. হয়ে গেছে তো আবার কি আমরা তো করে দিয়েছি not called upon. Appellant concludes not called upon to report. So we'll pass our order, Mr. Shah. Yes. এসো ডাকো।
Order pass করছে।
They are your other side or they are with you? We don't understand.
It's only order going to be pronounced, so it doesn't matter which side.
Bhattacharya is leading me.
I see.
This is an appeal
Don't worry.
under section 57 of the Arbitration and Conciliation Act 1996, within brackets, hereafter, the said Act of 1996, assailing an order dated July 9, 2025, passed by the Learned Commercial Court at Rajarhat, North 24 Parganas, in Miss.ARB, within brackets, number 12 of 2025, whereby the appellant's application under section 9 of the Arbitration and Conciliation Act 1996 has been disposed of without granting the interim. some follows. Appellate on entered into an agreement where an appellate subject to demolish certain structures, demolish the existing structures and block on sector 5 of Salt Lake on Kolkata 7 and take away the wreckage. Certain terms should be considered. Paragraph. In terms of the said agreement, appellant had furnished an interest-free refundable security deposit is 50 lakh. Agreement envisaged that the job of demolition executed in a period of 4 months with an additional grace period of 1 month. Terms of the agreement, appellant was entitled to take away debris taken on him on payment of a consolidated sum of rupees 6,50, within brackets rupees 6 crore 50 lakh, only exclusive of applicable services. Said amount was to be paid in 8 installments. And such installment was payable on release of approximately 300 metric tons of salvage each time to the applicant. Is the appellant's case that in terms of the appellant had submitted that would be employed by for the purpose of carrying out the demolition. Paragraph. And despite the readiness and willingness of the appellant, work could not be commenced prior to September 2024. Certain failures on the part of the respondent. Alleged that the respondent failed in statutory clearances from the relevant authorities within time, and that failed by basic communities at the site that caused inconvenience to the appellant in carrying out the agreed demolition. And Despite the respondent itself being at fault, went ahead. March 1, 2025, thereby terminating from that way that did the contentions, it notice of termination by a letter dated March 2, 2025, indicated that over 80% of the demolition work had already been completed. Subsequently, appellant came to learn from a letter dated March 6, 2025, that the government had filed an application under Section 9 of the Arbitration and Conciliation Act. Which had been registered as R from case number 8 of 2025. And that an ex parte identity order had been passed in favor of the such circumstances, the appellant constraint, which the London Commercial Court, by instituting its own application, Section 9, of case number 12 of 2020. Cases have been disposed of, consolidated order dated July 9, 2025, which has been your submission was only that you want this inventorization to be done.
Utilization so that the ultimately, my lord, the arbitrators, my lord, have some basis to work on instead of, my lord, leaving it to, my lord, some thumb rule formula or something else. So that, my lord, the arbitrators, my lord, have something to go by. Otherwise, my lord, I understand fully well, my lord, that the arbitrators will decide. But if they have no material on the basis of which to decide, now, my lord, if some material is there, then, my lord, arguments and counter arguments can be made as to how much was done by them, how much was done by me. But, my lord, if absolutely nothing is available, my lord, with the arbitrators, then, my lord, your lordship will kindly appreciate, my lord, what is the basis, my lord, on which, my lord, the arbitrators will, my lord, ultimately consider.
Mr. Shahan, I appreciate it for and of quantum and which generated thus far upon demolition was conducted by the appellant. Further, submitted that after the appellant, after the agreement between the appellant and his company was terminated, and a third party was introduced for carrying out the demolition, no further demolition work has been undertaken. Such submission has, however, not been accepted by the respondents. And which are not in dispute. A. Parties was executed on August 8, 2025. The work of demolition could not proceed 2024. The work of demolition could not proceed till September. March 1, 2025, agreement between the appellant and the respondents to terminate. 4/2025. Third party. The purpose of carrying out demolition work which was left unfinished by the appellant. Cataract. Do not dispute that of the refundable security deposit of rupees 50 lakh paid by the appellant. Sum of rupees 25 lakh paid back by the respondent to the appellant, and that appellant has been permitted to take away 50 metric ton of wreckage.
14 metric.
1/4. 14.
Yes, sir.
It is evident that with its application under section 9, about 1 month after the termination of the agreement between the appellant and the respondent, page 215 of that affidavit, the application form wished to get the work done by measured in terms of the quantity of wreckage generated upon the demolition work conducted by distance in time when more than 4 months have passed since the appellant's exit from the project site. Not serve any purpose. Direct special officer to make an inventory of the wreckage for the purpose of ascertaining of the wreckage for the purpose of ascertaining and the quantum of the same, so that ascertain the quantum of such wreckage that was generated prior to the third party coming in, carry out the balance work of demolition. In any case, as it appears from the order in view, the learned has reached a conclusion that the remedy of the appellant counts in damages. It would be for the appellant itself to prove the quantum of damage that is suffered. It would not excite within and assist any of them in unearthing the evidence which otherwise would have been the burden of the party who seeks to prove this case. One more point which weighs with us using past orders as claimed for is that today an arbitral tribunal has already been instituted. There is now a statutory interdict in terms of section 9, subsection 3, whereby the court is framed passing an interim measure for the constitution yes, the court finds that measures so far are such that it would not be applicable for the arbitral tribunal to pass the same out of section 17.
Non-commercial matter, number 1 to 3.
Commercial.
Non-commercial, commercial में धरी है.
One and
Assign.
have been assigned to your lordships. Lord, any day, my lords, want to keep it, Lord, we are ready to argue.
Not today.
Today, my lord, Mr. Mitro, Mr. Anindo Mitro,
Who is your other side?
Mr. Tonoy Chakraborty, and the learned advocate general also appeared to lead him on some occasions.
Nobody is there for the state. Tell us, give us a date. Tell us when.
Bolo, next
weekend.
next
weekend.
মানে মঙ্গলবার
মঙ্গলবার
আর বৃহস্পতিবার যে 14 তারিখ
14 তারিখ করে 14
non-commercial.
14th if it comments to your lordship.
Thursday.
Yes. In the meantime, I'll serve notice on the other side also.
Very well.
1 and 3 months.
These matters have been, these matters have been assigned To us, to our bench, to our bench. Stop. Nobody appears for the state today, capital S. Paragraph on the request of Mr. Arindam Banerjee, learned senior counsel, representing Borun. Representing whom?
And Raju Ghosh. Borun Malakar and the petition.
All the appellants.
The appellants in 1 and 3.
1 and 3. Raju and Borun.
Raju and Borun.
Who is appearing for Gautam?
Gautam.
Very well. Ki bollam?
On the request of Mr.
Appellants in MAT 812 of 2024 and MAT 847 of 2022, comma, let these matters be listed under the, for hearing, everything ready. Paper books.
No, actually there's an application for condonation of the pending, isn't it? Condonation allowed. Yes, pleadings are complete, but the paper books have not been directed. But
under the appropriate heading, on 14, August 14. All papers are before us. Shall we hear out the appeal?
My lords, kindly do so, because there's nothing remains of the. I mean, hearing it piecemeal won't.
Paragraph. We are told that all papers that were available before the learned, which this court, no,
Yes.
Single judge,
Yes.
learned single judge, have been filed with the appeal with the stay applications. Stop. Therefore, comma, we propose to hear out the appeal itself. Stop. Paragraph. Let this order be communicated to learned advocates appearing for the state.
Obliged.
Who's instructing you?
Mr. Ashish Mukherjee.
No, we just want to point out it's fairly long order. Eh? Yeah, appropriate money hearing kore diyo.
If your lordship puts in the last paragraph, urgent certified copies you applied for be made available to the parties on a priority basis, then it becomes a really long order. Then maybe.
Item 4.
Item number,
For the appellate by
not, I'm for the respondent. I'm led by Mr. Pronit Bagh.
Mr. Pronit Bagh.
He's on his legs in court number 1, my lord. I'm praying for a short Passover.
Passover.
Item 5.
Item 5, my lord.
5.
Yes, my lord, on behalf of the state, my lord, there's a my lord request, my lord, to Mr.
For the state. 5. Narottam Jana versus Mahindra and Mahindra.
Item 6. Seven. Eight.
I appear to the appellate. This is the matter which had started on a previous occasion. Rejection of my application under Section 8 of the Arbitration.
We'll come back immediately. Your other side is here. You are
Led by Mr. Banerjee, my lord.
You are here. That is good enough. Chalo, Dako, second call dhorbo.
Item 9.
My lord, I appear for the appellant, my lord. I'm led by Mr. Kundu. Devashish Kundu.
Passover.
Lordship.
10.
Second call. Yeah.
Second call, item number 4.
I am for the appellate.
Mr. Bagh is not here. Not today. Just not today.
Next occasion, Mr. Bagh not there, my lord.
No, please go and tell him then on the next occasion to request him to be here. We'll take it up.
I'm grateful.
Not today.
Item 5.
Usual order, Abhijit. 21 appeal.
Item 6.
Same.
Item 7.
Same.
7, my lord, I appeal not for the appellants. My lord,
Chandri Donnelly.
my lord.
Acha.
My lord, this is, my lord, an appeal from an order under section 9, my lord, passed by the London Alipur court. My lord, restraining, my lord, my clients, my lord, from dealing with the property, my lord. There's an arbitration proceeding, my lord, subject to the, my lord, the result of the arbitral proceedings. My lord, if your lordship is pleased to look at the order impugned, my lord, it's, my lord, it just, my lord, come to the operative portion, my lord, I think that will, because, my lord, it's, because the order was passed, my lord, quite some time back. My lord, the instant in this case be and hereby is allowed on contest. The respondents, their agents are restrained from creating any third-party interest by alienating or encumbering the property as described in schedule to the development agreement till the conclusion of the arbitral proceedings. My lord, this proceeding, my lord, after this order, my lord, the arbitral tribunals were constituted, my lord, presided by Mr. Shobushaji Chaudhary, my lord, and two nominees of the parties, my lord, and that is not at an advanced stage. My lord, the evidence, my lord, has also been concluded. So, my lord, I was praying, my lord, may this appeal be disposed of, my lord, with a direction, my lord, that the, my lord, we can, my lord, raise all points before the arbitral tribunal, and, my lord, this order, my lord, it already says, my lord, it is subject to the result of the arbitration proceedings. So, my lord, it will come to an end.
Fine.
Yes, that's what I'm saying.
That's right. So
That's what
therefore,
I'm
this order, we are not interfering with the order.
But I'm
Mr. Sinha fairly says that the arbitration proceeding is at an advanced stage. So whatever award the tribunal passes.
The order is only, my lord, limited till the disposal of arbitral. So, my lord, it will come to it. Yes.
Orderটাই খুঁজে পেলাম না এখন। এই আরে বাবা মেমোটা কোথায়? দেখো তো। ও মিস্টার সব্যসাচী চৌধুরী, মিস্টার অরিন্দম ব্যানার্জি।
Yes, my lord, they were. Yes, my lord, they were the.
And Mr. Surjo Ganguly, all three
All three
appeared before us today, I
Yes.
think, in the morning. Esho.
Well, it's an interesting arbitration, but the witnesses, my lord, are overseas, my lord. They are being examined virtually. My lord, it's a great experience.
Should be on commission.
Imagine my client
But
sits in Australia. I cross-examine one from here, eating veg food. The other is in London. I cross-examine her sitting here, eating veg food. I told Mr. Sinha that take me. Only I will go.
Veg food cover, veg food cover.
সব সময় veg food ওই খেতে গিনুড়ি ওখানে কি হয়?
Okay.
Virtual can't be real.
Virtual.
Virtual. This appeal is direct.
Note in the order. My cross-examination got completed.
This appeal is directed against an order dated September 20, 2021, passed by the Additional District Judge, 14th Court, Alipur, in Arbitration Miss Case number 53 of 2021, being an application under Section 9 of the Arbitration and Conciliation Act, 1996, instituted by the respondent number 1 herein. Respondent number 1 herein, praying for certain interim reliefs. Stop. The learned trial court disposed of the application by restraining the respondents in the Section 9 application, being the appellants herein, from creating any third-party interest, third-party interest by alienating or encumbering the property as described in the schedule to the registered joint development agreement dated 15th December, 2017, till the conclusion of arbitral proceedings, subject to compliance of Section 9(2) of the Arbitration and Conciliation Act, 1996, stop, unquote. Paragraph. Mr. Sinha, comma, learned counsel appearing for the appellants, fairly says that the arbitral tribunal that was constituted has proceeded with the matter and the arbitration is at an advanced stage. Stop. This appeal may be disposed of by clarifying that the order impugned shall abide by the final award of the tribunal. Paragraph.
No, Your Lordship,
Mr.
have not
Banerjee.
gone into the merits and all issues are kept open.
Yes, yes. Mr. Banerjee, comma, learned advocate representing the respondent oblique petitioner, has no objection to the same paragraph. Accordingly, comma, this application, this appeal being FMAT, is disposed of along with the connected application, clarifying that the order impugned in this appeal shall abide by the award of the arbitral tribunal. Stop. We make it clear that we have not addressed the merits of the case at all. Stop. The learned tribunal shall make and publish an award in accordance with law, without being influenced by any observation in this order or in any other order passed in this appeal.
I'm good. But in the section 9 proceedings, in the section 9.
In the section 9
I'm
proceedings.
grateful.
এই দুটো কেন আছে ক্যান দেখিনি একটা বোধহয় ডিসপোজ অফ হয়ে গেছে কিনা
But this appeal arises out of an order passed on an application moved by my client under Section 8 of the Arbitration and Conciliation Act, refusing to refer the disputes to arbitration and stay the suit. My lord, may I just show, which would be?
I am the respondent into opposing. Only one request. I have a parted matter going on for single bench, single bench. But if Mr. Bose finishes today, we'll kindly grant him another day to come back with our
Roughly how long will take, Mr. Bose? We are not.
I should take at least, I have some cases to cite.
Yes.
I should take at least half an hour to 45 minutes.
Very well. You see, 12:30 এটা কিছু fixed আছে.
I try and finish that, come out back.
Come.
My lord will be pleased to first take, though I've placed this order once, kindly, my lord, just to refresh your lordship's memory, kindly take page 50 of the petition where the impugned order is set out. 51.
A memo of let's stay up.
Today is fixed for passing order in the matter. My lord has found it.
Yes,
Page 51.
memorandum. All right.
My lord can also take the memorandum.
Yes.
Today is fixed for passing order in the matter of application under Section 8 of the Arbitration and Conciliation Act 1996. Record is taken up for passing order. Peruse the application under Section 8 of the Arbitration and Conciliation Act, the purported memorandum of understanding dated so-and-so, and the affidavit in opposition filed by the plaintiffs. In his application, defendant number 1 prays to dismiss the instant suit on the ground that the memorandum of understanding dated 30th of March 2012 executed between the plaintiff number 1 and the defendant number 1 contains an arbitration clause at para 5 of the said MOU. I shall place it.
You are Adhunik.
I'm Adhunik.
Lord, I understand this matter is going to take some time, and your lordship has a matter fixed at 12. But Mr. Kundu is leading me in item number 9.
But I am the other side.
Can it be taken up 2 p.m. then?
But,
Mr. Kundu can go back right.
I am the other side. I'm Bolachilo. But I am
2 p.m. may not be possible.
Anyways, Mr. Kundu will submit.
We'll adjourn it for the day then. We'll adjourn it for the day. No.
Anyways, Mr. Kundu after his submission.
He is not available, he is saying.
Next day I have to reply. Anyways, I cannot reply.
Mr. Kundu can conclude today. If you
I was not available at 2 p.m.
Item number?
The next matter.
Next matter. Very well.
Can I then come back for the reply next Thursday? Subject to your lordship.
Why be?
2 p.m. does not.
You will not be in court.
No, I'll be in court, but
Then better be here. Yes. Mr. Kundu, come at 2 p.m.
No, he'll make his submission. Can I reply the next day?
Why? If he finishes within half an hour, why shouldn't he reply today, Mr. Biani? Why tax our memory?
Because 2 p.m. I have other prefix matters.
Then let us release this matter, Mr. Kenny. If you have other matters, then go and do other matters.
Lordship, I did not take it that way. I'll come back. Okay. I'll come.
Yes.
Where did I start from? I have carefully, paragraph starting.
Yes.
I have carefully perused Annexure B to the application. On bare reading, it is found that name of the plaintiff number 1 is mentioned as the vendor in the MOU in respect of the suit premises. Herein, both plaintiff number 1 and the defendant number 1 are companies incorporated under the Companies Act. On the last page of the MOU, the director of the intending purchaser signed as a party under his office seal showing his designation and position in company. But the representation of plaintiff number 1 in the said MOU is not apparent. There is no such company seal showing identification, specification as to who had signed for the plaintiff number 1 and in which capacity or authority. The averment of the said MOU also does not disclose as to who and in which capacity and authority had signed the alleged document. In the purported document, there is no positive assertion to show that the plaintiff number 1 enters into that MOU.
Text 7.4. 29. Or 6 months.
I shall come to the law, my lord, in this.
These are all issues which perhaps now are to be decided by the tribunal.
Absolutely. Absolutely. But may I just please, may I show your lordship, my lord? On the basis of the above, but the representation of the plaintiff number 1 and the said MOU is not apparent. There is no such company seal showing identification specification as to who has signed for the plaintiff number 1 and in which capacity or authority. The averment of the said MOU also does not disclose as to who and in which capacity and authority had signed the alleged document. In the purported document, there is no positive assertion to show that plaintiff number 1 enters into the MOU. On the basis of the above facts, the court is of the opinion that it will not be safe to arrive at any affirmative conclusion on the basis of the said purported MOU, as the presence of the plaintiff number 1 in it is doubtful. As such, the court has held that the court holds, it must be, that the arbitration clause mentioned in the purported MOU has no binding effect on the plaintiff number 1. Hence, the application under Section 8 of the Arbitration and Conciliation Act filed by the defendant number 1 is rejected on contest without any order from the record, so and so. So, my lord, one thing is clear from the order. There is an MOU. There is an arbitration clause there in writing. It is signed by one of the parties. I'm assuming that the other party's signature is doubted. Now, the question is, are all these factors to be considered by court or by the arbitrator? For taking your lordship to the law, may I just take your lordship hurriedly through the relevant clause in the MOU?
Page 40.
The MOU, my lord, is on page 40.
Order admitting appeal, 21st January.
Yes, it has stayed the suit.
Stayed the suit.
It has stayed the suit.
Prima facie held that there's an
Oh, that is justice sent.
Common sense order, bench presided. Is it my lord's pleasure I place that order once?
No, no.
It is readily available with me.
MOU at page 40.
Yes, MOU is at page 40. Now, instrument of MOU is made on the 30th of March in the year 2012 between LMJ Business Center Private Limited. That is the respondent here. I'm sorry, my lord is looking for it.
What do you have this
Page 40.
Onek number lekha ache.
Refer to successors. on the first part, and Adhunik Infotech Limited having its office and so and so, referred to as the purchaser. The purchaser has agreed, my lord, A, the purchaser has agreed to purchase all that the commercial space number 7 on the 7th floor of the building named Lansdowne Tower containing so and so. I'm not going into all that. The money aspect, my lord, on page 41, now this memorandum of understanding witnesseth, and it is hereby agreed and declared by and between the parties as follows. In consideration of the above, the purchaser herein has agreed to pay to the vendor a total consideration sum of 10 crores 51 lakhs only, being the total consideration payable in respect of the said property, out of which the purchaser herein in part performance has paid to the vendor herein at or before the execution of these presents.
Your suit is for specific performance. Yes.
Eviction.
It's for eviction.
Yes.
Possession.
And I'm in possession.
No, that's all.
Let me.
Now use the property.
We only wanted to know the prayer in the plaint. That's all.
I should show your lordship, and they are aware of this MOU. They refer to it in the plaint.
My lord, not like that, my lord.
Anyway,
That's sufficient.
yes, you will. So out of which a sum of rupees 2 crores only, and out of the balance sum of 8 crores 51 lakhs and odd, a sum of 1 crore will be paid on 31st March 2012, and the balance sum, etc. Now, my lord, kindly see a sum, page 42, a sum of rupees 3 crores 76 lakhs by 15th May has been paid. Now, kindly come to the arbitration clause at page 43, clause 5. Very clear. In the event of any dispute or difference arising between the parties concerning the meaning or interpretation of these presents and of the rights and obligations of the parties hereto, the same shall be in accordance with the relevant provisions. Well, I believe the word referred is missing. Shall be in accordance with the relevant provisions of the Arbitration and Conciliation Act 1996 or any statutory modification or reenactment thereof for the time being in force. The arbitration sittings shall be held at Kolkata only by the Arbitral Tribunal having summary powers. So the arbitration clause is clear. The seat of the arbitration is clear. It is an arbitration clause which is in writing. Now, my lord will be pleased to see the signatures on page 44.
Shareholder director as a shareholder, 25% shareholder as a when he signed this.
S.K. Jain, he is
Signed on behalf of
he is, my lord, a shareholder director. It is admitted in this MOU.
No, in LMG.
In the respondent.
Number 1.
What is the full name of SK Jain?
LMG.
Suresh Kumar.
Suresh Kumar Jain.
Suresh Kumar. Very well. All right.
It is admitted in.
So SK Jain, and then
this is the witness.
The witness is RK Sethi. He's the founder director. And
Director who shares.
For Adhunik, the signature is there of a director.
Now, after this possession agreement.
Now, kindly come. This document of MOU is dated 30th of March 2012. I believe my lord has noticed that at page 40.
Page?
Page 40 is the date of this MOU.
Yes.
30th March.
30th March. Now come to page 45. 31st March 2012, the very next day. Possession is given. This is to confirm that on this, the 31st day of March 2012, we have put you in complete vacant possession of our office block. We hereby confirm that you shall be entitled to hold, possess, and enjoy the said office block without any interruption or hindrance from us or any person claiming through or under us. While holding the office block and around from the date of possession, you shall be entitled to and are hereby authorized furniture, make payment of all amounts, etc. to hold, possess. Signed by Sunita Jain, once again a director of the respondent number 1 at the relevant point of time. It is, if my lord turns the page, and it is witnessed also by S.K. Jain, who is a promoter director. Naresh Jain, who is a promoter director.
Of respondent.
Page 46. Now, my lord, it is very important to see what is the case with which they have come in the plaint. The plaint, my lord will be pleased to find in page 3-0.
13.
1-3
of the stay.
of the stay application.
Right.
It starts at page 14. Suit filed in 2015. MOU is 2012, possession in 2012. Suit filed in 2015. LMJ Business Center Private Limited is the plaintiff number 1.
What is the suit number?
Suit number is
53, 51. 532.
532
532
of 2015. man.
of 2015.
Yes.
LMJ is the plaintiff number 1. Adhunik, the appellant before your lordship, is the respondent number 1.
They have made their shareholder.
And Suresh Kumar Jain, a shareholder, is the defendant number 2
Shareholder
of Adhunik Infotech Limited. They have made a shareholder of Adhunik, Suresh Kumar Jain,
who is
the defendant number 2.
He
He had executed the MOU. Now, my lord, I need not place
Signed the MOU on behalf of LNJ?
of LMJ. LMJ Suresh Kumar.
for LMJ, my lord, Suresh Kumar Jain.
Yes.
Kindly come to
For
page
LMJ
40.
Suresh Kumar Jain.
Yes.
But Suresh Kumar Jain is a defendant in the suit.
Yes,
That's why they made him a
that
defendant.
is why they made him a
They're
defendant.
saying he could
Oh.
not. They're saying that's the fraud.
And these are the small internal family disputes of fraud which have to be and can be
No public domain. Not
to be decided by the arbitrator, because your lordship knows the recent current line of judgment.
Adhunik is also a family concern of the Jains. No. No.
only LMJ.
Only LMJ.
No, my lord.
Any element of settlement through mediation.
I do not know, my lord, will ask them. Because your lordship knows the law very clearly.
When lordships inquired that what is the suit for, I submitted that it's for eviction. They have shown the possession letter. The premises has all throughout been lying vacant. What they are doing is they're stopping me from entering.
My lord will take the plate.
And my lord, so far as the mediation possibility is concerned, SK Jain, he is never connected with this company.
We'll show it is in the plaint. He's a shareholder.
Shareholder, director.
Can the dispute between Adhunik and LNJ be settled through mediation? You think? This was a simple question.
Forgive me, my lord. My lord, I'll have to take instructions.
What about you? You think it's possible?
My lord,
We are on a mediation drive now.
my lord, I really do not know. I'll have to take instructions. At this moment, it is not. But the MOU is referred to. My lord will be startled to read the plaint. They know everything. They knew everything. They talk about the letter of possession. They say there may be such a letter, and just it has to be decided by an arbitrator. But of course, if mediation is something which my lord wants us to consider, we'll have to take instructions.
Do so. Do so. Because that will inure to everybody's benefit. If the parties agree.
Anyway,
Agree to
my lord,
arbitration, my lord.
no.
Mediation.
My lord, though my learned junior says that it may not be possible, but he's saying so, my lord, without taking instructions. So let us take instructions and we will come back. Because may I just show the plaint? Because then if they don't agree, I can straight away come to the law next day. Otherwise, my lord,
Taken
let us take
peaceful possession, mean profit. Basically,
yes, eviction.
eviction.
And kindly see certain paragraphs.
To show how Suresh Jain they have admitted is a shareholder.
Kindly see paragraph 3. My lord, if my lord is thinking in
How much you have received till now?
Thing.
3 crores as per them.
0, my lord.
Very well. Yes.
This has been appropriated by that person called SK Jain.
He was a shareholder.
The company, my lord, there's a second order passed by Justice Sen. That was a misapprehension created upon the court. A lie.
The second order of
I don't want to, my lord, interrupt my,
Yes.
I'll place
Does my lord want us to pursue your lordship's drive, or
Yeah.
shall I continue?
No, no, please pursue. Please take instruction.
Well, look, then next week I'm in a little difficulty. Kindly fix this matter on the week beginning 18.
Issue?
my lord. May I make one clear, my lord? My lord, my suit has been stayed.
Yes.
The witness action was going on. What do I do about it?
This appeal is directed against an order dated March 22, 2021, passed by the learned civil judge, bracket Senior Division, Second Court, Alipur, in an application taken out by the present appellant, bracket defendant, in title suit number 532 of 2015, whereby, the application under section 8 of the Arbitration and Conciliation Act, 1996, taken out by the defendant number 1 in the suit, being the present appellant, was dismissed. Paragraph. The suit is for eviction and mean profits. Stop. The appellant says that the suit is not maintainable since the memorandum of understanding dated March 30, 2012, on the basis of which possession was handed over, possession of the suit property was handed over to the appellant, contains an arbitration clause. Stop. Paragraph. We inquired of learned counsel appearing for the parties as to whether or not the disputes between the parties could be resolved through the process of mediation. Stop. Learned counsel for both the parties seek time to obtain instruction in this regard. Paragraph as requested, list this matter once again on August 18. No, 18 kotobar?
I think is a Monday, and then it has to be 19th.
August 19. Later now.
Grateful.
My lord, Banerjee is not there on that date. I'm just informed on 19th. My lord, maybe some other day.
First,
My lord.
21 করে দাও।
Grateful.
Okay.
টেন টেনে তো কেউ ছিল না। 10 কি বলছি না। পেপার বুকস ফাইল হয়েছে? student special treatment কিছু হবে না, usual order. আবার এসে মেনশন করলে restored, usual. হয়ে গেল তো। এবারে কমার্শিয়াল, এইটা 2 PM হবে, 9 নম্বরটা।
Item number 1.
My lord, let's pay for short Passover.
To be mentioned, you'll pray for a Passover.
Sir, Banerjee is on his legs just beside this school. Short Passover.
You are appearing in the matter. Why is it appearing as to be mentioned?
Lordship, I think.
My lord, what had happened was, my lord had initially.
Oh,
considered
interim
some-
order.
Yes, ma'am. My lord, may kindly, because lordship, it was our prayer, because my lord had already kept 18th similar matters where the appellability was.
Pass it over, sir. They are seeking a Passover. We'll come back.
My lord.
Yes, 3.
Item number 3 for the applicant may be fixed in the coming week, your lordship, because there was a mediation that a settlement was between the parties. Mr. Banerjee.
Mediation is in progress.
No, not progress, your lordship. The mediation has failed, your lordship. That's why your lordship has fixed the matter today for hearing, your lordship.
Amongst the parties,
Parties-
the solicitors we tried,
But
it has
we failed.
That is hardly any mediation.
That was a talk of settlement between the parties, your lordship.
If you want to really, what is the nature of the dispute?
I am the plaintiff.
Money claim. Why don't you try proper mediation? Between solicitors is no mediation. We don't recognize that. Who is the claimant? Who is the plaintiff?
I am the plaintiff, your lordship.
You have got a
started
decree.
counterclaims. His client is not willing to go into the counterclaims.
Because
His
the
client says, I have put in my claim in a suit. If you put in your counterclaims, good luck to you on your counterclaims.
No, no.
So far as my client, that's what has come to.
For a
But
amount of
I have not
immediate
participated, my
damages.
lord. I have at the very beginning, my lord, I have sounded a short caveat to myself. I am a very, very, very poor mediator. Therefore, I did not participate because my introduction in the scene would make the scene a bit pugnacious, which is not required. Therefore, the good offices of Mr. Chaudhuri, my lord, were taken, and I am sure that Mr. Ashish Mukherjee also tried his best. Twice they have sat, twice or thrice. They say that there has not been. They don't want a total consideration.
Mr. Banerjee, if, with due respect, if the learned advocates could settle all matters, then mediation would not be necessary. These are trained mediators.
There are ways and techniques.
You are also a trained mediator, aren't you? You are not.
But next time it happens, not I'll definitely.
Yes.
The lordship pleases to appoint someone, we are willing to go.
If you are willing to go, you also take instruction.
We are willing to go.
Can we refer the matter then? Exercise your discretion, counsel's discretion, Mr. Banerjee. Yeah, that a power issue. Having heard learned counsel for the parties, comma, it appears that there is an element of settlement in this matter and the disputes may be resolved through the process of mediation. Paragraph, the member secretary of the High Court Mediation Committee is directed to take necessary steps so that mediation may be held in respect of the disputes between the parties. Paragraph, the registry is directed to communicate this order immediately to the member secretary of the High Court Mediation Committee. Paragraph, list this matter 4 weeks hence. Stop. On that date, comma, the mediator shall file his/her final report or interim report. Go, try. What is the decretal amount?
Not a decrease. The claim amount in the suit is around 6 crores.
Suit has not been decreed.
From an injunction.
Interim order.
Interim order, injunction has been.
We say we have not been heard. My lord was minded to remand it back on. No. Minded to prima facie. Minded to remand it back on the injunction not getting vacated, with giving us an opportunity to contest the matter.
Now this is a different kind of remand to mediation. All right.
Because there's a cap of 5% on liquidated damages. Should be agreeable to.
Let us.
Yes, let's hope that good sense prevails.
Let's hope. Chalo. It is a Ranjan. Mr. Bachawad is still not coming. He has come.
Yes. We were on the Copyright Act, my lord. Kindly takes the Copyright Act also.
Let us take the break and come back so that otherwise after 5 minutes we'll have to rise.
As of the very next matter, the new built
Yes.
Yes, Mr. Anirban Ray was appearing, he is no longer there. On behalf of the state, there is a request for engagement.
For the respondent, 37 appeal. Whenever the matter is fixed by your lordship, they are having difficulty. This is continuing for
may I
1.5
conclude my
months.
submission, then kindly. But Anirban Ray was appearing, he is no longer there. We have not requested for engagement to learn advocate general. That process will take about a fortnight's time. So,
Their money is stuck, Mr. Sinha. Try to expedite because Mr. Ray resigned. Now it's 4 weeks now at least.
I have not the letter by which.
Understand, we are not blaming you for a moment. Your department or whoever has issued this letter should have been more prompt. But we'll keep it very well since you say so. Keep Tariq,
Not appearing alone, my lord. He is appearing with the juniors. But let the matter be open and be started. Argument, he will take up the matter.
Yes, next day, Mr. Sinha, please ensure somebody is briefed now that you have that letter for appointing somebody. Ajke koto tarikh bolle? 7th. How long does it take to brief somebody?
No. The engagement has to be approved by the LR. It's an appellate side matter, so it has to be approved by the LR. That is 19th. 19th. Accommodation is sought for on behalf of the Likcho. Appellants. Stop. It is submitted that learned government pleader who was representing the state in this matter, has tendered his resignation. Stop. New engagement of counsel has to be made. Paragraph. Mr. Sen, learned advocate appearing for the award holder, makes a grievance that for a long time this appeal under section 37 of the Arbitration and Conciliation Act, 1996, is pending. Stop. On one pretext or the other,
the state is delaying hearing of the appeal. Stop. Paragraph. Let this matter be listed once again on Kavivullam. 18, 19, August 19, 1990, 2025. Stop. It is understood that on that day, the appellants shall start argument. Hey. You feeling better?
Much better. my lord.
Before you resume,
Yes.
any chance of having the disputes resolved through mediation?
Lord, in this kind of matter,
No.
my lord,
We'll appoint Mr. Mukherjee as the mediator.
Lord,
He's a trained mediator.
Lord, I for one would be very happy, particularly if Lord the mediation is held somewhere in the Himalayas, but because this relates to that area, district Darjeeling.
Proceed.
Lord, I'll be very brief. Lord,
Allow us 1 minute.
yes, yes. Okay. Judgment থেকে দেখবি। না না তুমি ছিলে না বলে হুশ করে দিয়েছি হ্যাঁ আরাম আরাম গান বাজনা হবে বাজনা হবে লিরিক্স আর পারফরমেন্স ও পারফরমেন্স পারফরমেন্স দেখে
এটাই পাবে। Yes.
But on the last day, I was showing your lordship some sections.
Yes.
But just to save time, what I'll do is I'll take your lordship through two judgments where not all the sections, relevant sections are cited. Now, my lord, before doing that, my lord, may I just try and my lord, put a perspective on our rights. My lord, like I told your lordship, my lord, the plaintiff before your lordship represents the rights of my lord, people who write the lyrics and the music. Not for songs. They may be film, they may be non-film, it doesn't really matter. Now, Lord, these are the real
good till 12:30?
Yes, 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 yes. Now, two judgments will take that time. I'll take 5 minutes
For the
on
benefit of
talking
Mr.
Gabi.
Mithro. For the benefit of Mr. Mithro.
Oh. He asked me,
I
Lord,
was trying to get out, others said good.
Lord, he asked me, but I told him, look, you better wait and watch. There's going to be music, there's going to be song, and there will be a performance.
Very well, yes. No, at 12:30 there is a matter fix.
I have a matter fixed at 12:30 before my lord.
Oh.
If today lordship continues with this, I will be very happy.
It's your matter at 12:30.
I got bombed by Mr. Bachawat. This item number 4 will carry on for long. I was waiting, suddenly I saw item number 5.
Otherwise, my lord, I have to. If he carries on today, my lord,
We don't know.
It might be such that I'll give the reply on the next day after hearing.
Yes.
So, just to put my rights in perspective, we represent the people who write the music and also the lyrics. That's really the creative force behind all song, most of it. Now, it's in this background, these rights your lordship has seen have been recognized under the Copyright Act. The Copyright Act, earlier had a slightly different form prior to 1994, because music, lyrics, these were not seen to be huge, humongous rights, not in the absence of private TV, private radio, etc. But with the explosion of these rights, new rights were recognized under the 1994 Act, and I've showed your lordship some of those sections. Now, what they seem to recognize, I'll put my case very high for the time being. Just to show your lordship, copyright, not as far as copyright is concerned, whether it is to do with not art or other forms or music, not a kind of special protection is given to it, particularly in not deciding whether others should be stopped from using these rights. Now, the basis behind this is not copyright is viewed as a property right. Even though not physical property, it's viewed as a property right. It is my property. I decide how it is to be used or not used. If you want to use it, you have to pay what I asked for or not at all. You can't say what I'm asking for is arbitrary. If you say so, there's a mechanism not provided under which you can go and challenge. But this absolute ownership right is not recognized. That's one part. The second part is not in enforcing these rights. The courts have not come to a finding not over time that this kind of infringement of these rights cannot be not compensated in money. Damages will never do, which is why injunction is granted as a matter of course. That also I'll show your lordship. So it's in this background that one looks at it. Now, I would be emboldened to say that as far as these rights are concerned, the rights seem to be almost absolute. One will have to pay to use the lyrics or the music in any form, whether it is in the form of a film, whether it is in the form of a sound recording, whether it is used in a public auditorium or in a hotel room. That's the scope of the judgments. The limited exceptions are very few, which I perhaps can't avail of. One exception is if one is getting married or a religious ceremony, then one cannot choose to play music in the course of a religious ceremony, and an Indian wedding is seen to be a religious ceremony. So it may be possible to say that's an exception. There are a few other exceptions, which is playing in private in a room, in your own house.
So one of the ways of getting around the law is to get married. All right.
I can't say I'm bold enough to look to do it a second time. I will have to fondly hope that my children do so at some point of time.
All right. Yes.
So, of course, I deliberately said that. There are very few exceptions. It seems to be absolute. One of the exceptions is Section 52 of the Copyright Act, which I'll show your lordship. So, I would not put my case as high as that and say it's an absolute right. Now, as far as my learned friends' clients are concerned, now, what is happening over here? There is a hotel. A hotel has got, let's say, 50 rooms. Now, some categories of hotel may offer air conditioning, some may offer central air conditioning, some may give running hot and cold water. And by that, I don't mean a boy running down with a bucket of water, but these are facilities provided to a guest for which they are charged. Now, in the course of that, with time, your lordship has seen it's now standard to provide for a TV in the room. It may have a set-top box, it may not have a set-top box. It gives the right to the consumer to choose and go and see what he wants to. He may or may not actually use it, but he is still being charged for it. Most often, business customers will walk into a hotel at night, not even bother switching on the TV. But the fact that there is a TV means there's an enhanced pay. Now, as far as he is concerned, therefore, he is providing TVs, that is not disputed. He's got set-top boxes, not disputed. If one switches it on, one has access to songs over which I am entitled to claim royalty. This is not the given background. Now, this very question of, well, what happens if no one ever switches on the TV in a hotel room? Are you still entitled to charge royalty? This question itself has been answered, and in the case of a hotel. And that probably puts an end to any argument my learned friend will have. So, since I'm covered by this judgment, instead of showing your lordship all these sections which are considered over there, may I just place that first? I have already given a copy to my learned friend earlier.
How could you make copy? You have copyright.
My lord, I gave him the reference. I didn't give him the copy. Hey, you given an infringing copy.
Yeah, legal copy. Licensed version has my name on it.
My lord, your lordship will find on top of that judgment, my lord, the name of a certain gentleman who has been licensed to make copies and circulate to your lordship.
Yes.
Therefore, this is a licensed copy.
Yes.
Even this required a license.
All right.
And this is part of copyright law. My lord, this has been actually these head notes and other things and the format in which these judgments are placed are the subject matter of a my lord, judgment of the Supreme Court. My lord. Eastern Book Company versus Modak. Now, my lord, if your lordship sees this, my lord, it's a judgment of 2008. My lord, just bear in mind that in 1994, the Copyright Act was amended, and I'll show your lordship the effect of some of those. So, my lord, this came in 2008, and my lord, if your lordship sees para 2, according to the plaintiff amendments, plaintiff is the copyright holder of a variety of literary and musical works, not our case. There, they were also not owners of sound recording, music videos, etc. Not we are not concerned with that. It's only to show that. Then, my lord, para 3, your lordship will find facts also identical. Plaintiff of ours that after coming to know about the alleged infringement of copyright in a variety of works, it asked an investigator to visit the premises of the defendant in order to ascertain the extent of viewing, etc. And my lord, he played it. Your lordship will find a few lines down. He switched on different channels in a room. Lord, which is also not identical to the facts of our case. Now, my lord, I'll also not trouble your lordship with the arguments made on both sides if your lordship turns to para 6. Because, my lord, those are all the arguments available here. Not para 6. Mr. Amit Datta, learned counsel for the plaintiff, relying on the affidavit of the investigator, contended that the titles in which it had copyright were in fact being played in the hotel rooms without a proper license. He states that such usage would amount to public performance or communication to public of the work, the exclusive right of which was granted only to the copyright holder or to a duly licensed person under the Act. He submitted that one of the exclusive rights prescribed by Section 14 of the Act in the case of literary, musical works, recording and cinematographic works is the right to communicate the work to the public, which is being infringed by the defendants. He also drew the attention of court to Section 2FF, not which I have shown your lordships, that defines communication to the public as occurring when a work is made available to the public directly or by any means of display or diffusion, regardless of whether the work has been seen or heard. So, my lord, it doesn't require that someone switches on. The fact that it is made available is good enough is the argument. The explanation to Section 2FF inserted in 95 specifically mandates that making a work available by simultaneous means of communication in hotel rooms would amount to communication to the public. Relying on the statement of object and reasons of the amendments of 95, he submitted that the intent of the explanation was to clarify the statute about the meaning of public, and therefore, in effect, the explanation clarifies that guests in the rooms of the hotel are a distinct public audience. Further, he argued that Section 51 states that any act in contravention of the exclusive rights conferred under Section 14 amounts to infringement. Communication to the public of the works of the plaintiff prima facie amounts to infringement of rights of works of the plaintiff, amounts to infringement of its rights. He placed reliance on 51A1 and 51A2 of the Act and contended that both primary and secondary infringement. Then, my lord, para 7. It is submitted that guests in the defendant's hotel rooms would amount to a distinct public audience, since as the defendant provides the service directly to the customers and not the cable operator. The television sets installed in the room by the defendant are the means through which electronic signals are converted into audio and video signals, and therefore constitute a separate act of communication to the public, distinct from the act of the cable operator. He relied on, now, my lord, these are interesting English judgments, my lord, if I may just, my lord, but going back into the 1930s when only a radio was available. So, my lord, please see how the English courts have dealt with it. He relied on the judgment of Performing Rights Society versus Hammond's Brewery, 1934 Chancery. In that case, the hotel had installed a wireless set. and loudspeaker that was made available musical works to a person visiting the hotel. In the appeal filed by the hotel, while holding the hotel was liable for infringement of copyright, Lawrence J. held as follows. The question therefore resolves itself into whether the defendants, by operating the wireless set, but please read that as radio, I suppose that's what it means, were causing an acoustic representation of works to be given at the hotel. In my judgment, that question must be answered in the affirmative. The wireless receiving set, by means of which alone the sounds were produced at the hotel, belonged to and were under the control of the defendants, who operated it for the purpose of giving their customers at the hotel an acoustic representation of the musical works being performed at Hammersmith. But the defendants, having put their wireless sets in operation there, would have been no acoustic representation of the works at the hotel at all. I find it impossible to escape from the conclusion that the owner of a receiving set who puts it into operation causes an acoustic representation of a musical work which is being broadcast to be given at the place where the receiving set is installed, and is therefore himself performing or authorizing the performance of the musical work within the meaning of the Copyright Act. So, my lord, this was during the radio days. Now, my lord, please turn to para 9. Now, the arguments which were put forth by the hotel owner, my lord, para 9. 4 main arguments, my lord. Mr. Mudit Sharma, learned counsel for the learned counsel, submits through the affidavit of the investigator, plaintiff has admitted that the content was being provided by the cable operator through various channels and not by the defendant. So he says, look, defendant is doing nothing. A cable operator is providing the signal, and that is all that I'm providing in my hotel rooms. This is the first argument. In relation to direct content being provided by the defendant in the bar, in the restaurant bar, by playing recorded music, investigator has not disclosed whether the defendant was in fact playing the plaintiff works. We are not concerned with this, but he is not playing it in a bar as I understand it. Therefore, he argued no cause of action has been established against the defendant. According to him, the plaintiff has neither made any averment in relation to the broadcast itself being unlicensed, nor has he made the broadcaster party for the present proceeding. Now, the next argument, if the broadcast itself were not illegal, he contended that the broadcaster would be entitled to broadcast reproduction rights under Section 37, which allows the broadcaster to communicate the work to the public. The broadcast itself and the receiving of such broadcast he submitted would not amount to infringement. So, put simply, he says, look, if the broadcast itself is not illegal, then my providing the broadcast to a customer will not be illegal either. That's the argument. He submitted that the defendant was merely receiving the signals transmitted by the cable operator, and because the plaintiff does not dispute the legality of the cable operator's content, the defendant itself could not be held liable for infringement. So, this is the third argument. And then, the fourth argument, para 10. Learned counsel for the defendant next submitted that the plaintiff has no locus standi to file the present suit, as an independent copyright of the broadcaster subsists in a broadcast, and the latter is the owner of the copyright. So he says, when there is a broadcast, the owner is the broadcaster, not you. This is the fourth argument. And then, my lord, if your lordship then turns to para 11. Lord. So these are the 4 broad arguments, my lord, which were made. Now, my lord, the act is considered. Section 2FF, which I had already placed, my lord, is set out. I'll just place that once more for your lordships, not very usual. 2FF. Communication to the public means making any work available for being seen or heard or otherwise enjoyed by the public directly or by means of display or diffusion other than by issuing copies of such work, regardless of whether any member of the public actually sees, hears, or otherwise enjoys the work so made available. So it doesn't matter, my lord, making it available is good enough. Then, my lord, the explanation is also important. For the purpose of this clause, communication through satellite or cable or any other means of simultaneous communication to more than one household or place of residence, including residential rooms of any hotel. So, my lord, makes it clear that, my lord, if it is made available to, my lord, residential rooms of a hotel, my lord, it is communication to the public. Then, my lord, meaning of copyright, section 14, my lord, I've already placed. And, my lord, if your lordship sees section 14, my lord, the copyright, my lord, Not if I may read it, for the purpose of this act, copyright means the exclusive right subject to the provisions of this act to do or authorize the doing of any of the following acts. Now, in our case, my lord, if your lordship sees A, in the case of a literary, dramatic or musical work, we are concerned with the literary or the musical work not being part of a computer program. Not one, to reproduce the work in any material form, including storing of it in any medium or electronic means. And my lord, if your lordship sees 3, to perform the work in public or communicate it to the public. So the owner of the copyright has that exclusive right. That exclusive right is given to him to allow it or not to allow it. And then, my lord, if your lordship comes to para 12, my lord, to tie it up, section 52. Section 52 defines what copyright infringement is. Sorry, that should be 51. It reads as follows. When copyright infringed, copyright in a work shall be deemed to be infringed when any person without a license granted by the owner of the copyright or the Register of Copyrights under this Act, or in contravention of the conditions of a license so granted, or any condition imposed by a competent authority, 1, does anything the exclusive right to do which is by this Act conferred on the owner of the copyright. So, my lord, one has to then go back to section 14, exclusive right given to the owner of the copyright to, my lord, allow communication to the public. So this is how, my lord, it comes back in through, my lord, section 51. Then, my lord, please also come to, my lord, the section is set out. Please see the explanation at the bottom, my lord, just before para 13. For the purpose of this section, the reproduction of a literary, dramatic, musical, or artistic work in the form of a cinematographic film shall be deemed to be an infringing copy. Now, here, my lord, I'll just make a comment which is not connected to this. My lord, like I said, there are very few exceptions to when, my lord, these works can actually be used. But one of them is this, and it's something which your lordships perhaps no longer do. Lord, going to a cinema hall and watching a film, Lord, the film producer, by displaying the film, or the cinema hall owner, by displaying the film, does not infringe the copyright of the lyricist or the composer or the sound recording company. That's one of the exceptions, because it is merged to, it has merged into the film, but only for the purpose of showing it in a cinema hall. That's how the Supreme Court has not construed it. So it's only in a cinema hall that the rights of the producer of the cinema will prevail over the rights of the lyricist or the composer, but only for that limited purpose. Then, my lord, section para 13, my lord. Like I told your lordship, the other exceptions are in section 52, and they are, my lord, noted over here. Certain acts are deemed not to be infringement under section 52. They include, under section 52 1K, use of recordings of musical works. There is also another exception where use is for a religious occasion, 52 1KA. These provisions read as follows. Causing of a recording to be heard in public by utilizing it in an enclosed room or hall meant for common use of residents in a residential premises, not being a hotel or a similar commercial establishment, as part of the amenities provided exclusively or mainly for the residents, or as part of the activities of a club or similar organization which is not established or conducted for profit. Then, the performance of a literary, dramatic, or musical work, or the communication to the public of such a work, or of a sound recording in the course of a bona fide religious ceremony, of an official ceremony held by the central government or the state government or the local authority. And the explanation says, for the purpose of this clause, religious ceremony includes a marriage procession and other social activities associated with marriage. So, my lord, this is that exception, but my lord, carries a dangerous rider. It must be a bona fide religious ceremony. So, my lord, if accompanied with drinks, as happens in a lot of weddings nowadays, I don't know whether one could call it a bona fide religious ceremony. But my lord, this is one of the exceptions. But that's the subject matter of a number of litigations which are pending, because my lord, notifications, clarifications by the central government about, well, what part can IPRS claim, what part can PPL claim, can they step in, Lord, when there's a wedding function, Lord, happening. So there's been a lot of litigation relating to that. We're not concerned with that, Lord. Then, Lord, para 14. Lord, Now, my lord, here the consideration. The copyrights conferred under Section 14 of the Act consists of a bundle of rights. The owner of a copyright is entitled to assign and license each of those rights separately or in bundles. The bundle of rights could vary in complexity depending on the nature of the work: literary, dramatic, musical recording, cinematographic film. In the case of music videos, which is essentially a cinematographic film, rights could subsist in the following works: similar lyrics, literary work, music composition, musical, choreography and performance, dramatic, the sets, artistic, etc. And Lord, each of these rights, your lordship will find it says could be assigned, reassigned, and licensed. Then, my lord, if your lordship comes to para 15. Now, deals with cable TV from here. We are concerned with the rights of plaintiffs in such cinematographic films. In relation to cable channels, the plaintiff could convey the right to broadcast the work to the public. They, in turn, could convey the right to rebroadcast the work to cable operators, and what is conveyed to the customer is a license to watch the work. This trail of conveyances have to be kept in mind. One of the earliest cases on the issue appears to have been decided by the US courts. Now, this again is 1930s. The court acknowledged that the owner of a private radio receiving set, who in his home invites friends to hear a musical composition which is being broadcast, would not be liable for infringement, for even if this be deemed to be a performance, it is neither public nor in profit. It was held, however, that the acts of a hotel proprietor in making available to his guests, through the instrumentality of a radio receiving set and loudspeakers installed in the hotel and under his control for the entertainment of his guests, the hearing of a copyrighted musical composition which has been broadcast from a radio transmitting station would constitute a performance of such composition within the meaning of the Copyright Act and thus violative of the owner's rights. Then, my lord, Coppinger, which is the authority on this subject, Coppinger, Volume 1. And here again, Lord, your lordship will see it considers the case of a hotel. It has been decided, not Coppinger is quoted, it has been decided by the Exchequer of Canada, Admiral Corporation versus Rediffusion, that the performance of material by way of television in private homes, the material having been received by subscribers to a cable service, did not amount to public performance on the ground that the character of the audience was purely domestic, and even a large number of private performances could not be in public. It might therefore be argued that the character of the audience in separate hotel rooms, hotel bedrooms is similar, each bedroom being the occupant's home for the night and each performance being private. So, my lord, now they are looking at the argument of not one being within one's own bedroom in a hotel and whether that will convert it into a private space. And, my lord, please see thereafter see examples of Mellor versus Australian broadcasting. So, my lord, law across the world. Lord, Australia, appeal cases, then, Lord, in a decision of the Supreme Court of New South Wales, see also hotel so and so, Lord, all these are given, and Finland. And if your lordship turns the page, provision of music by taxi driver to his customer. The issue arose whether the watching of television sets by the occupants of motel rooms to which films were relayed by means of a video cassette recorder and cables amounted to public performance. The plaintiff's case was argued primarily on the basis that presentation of a film in a single room, even to only one person, amounted to public performance. It was held that such presentation was in fact public, since the character of the audience was as guests of the motel and not as individuals in a private or domestic situation. In that capacity, the guests were paying for the accommodation and the benefits which went with it. It was thought that the same reason for performance of the works to inmates of prisons is also in public. So, my lord, this is the law across the world. Your lordship is seeing it's considered across the world. Then, my lord, your lordship can come to para 19. Or, my lord, para 18, if I may please. But the expansive definition under section 2FF in this case would mean that broadcast is deemed to be communication to the public. I'm sorry.
Your other side is here, Mr. Banerjee. Is this the 12.5? No. 12.5. Mr. Vajwa, the 12:30 his matter is fixed. So when will you come back?
Any day convenient to your lordships. I'm there for your lordships. Whatever. But I will take perhaps not 40 minutes more, not maximum, maybe less. Because placing this judgment will take care of most things.
Hey, Lekho, it will be the first item under hearing, zero mache. Huh? Mr. Bachawat, learned senior counsel representing the appellant, resumes his argument but does not conclude. Paragraph. As requested, list this matter once again on Tuesday.
Mr. Roy Chaudhary
Thursday?
on Tuesday.
Thursday, retaining its position. Thursday night, date ta diye dao.
এটা আমার না।
My lord, I apologize for intervening, lordship. This is with respect to item number 1, which was kept as to be mentioned today, my lord. My learned senior friend was not there at the time of call.
My lord, I have no issue. My lord, I can go for it. Because
Lordship, this is only for the purposes of extension till 18th, because my lord had already kept that. My lord had initially given us a protection for 10 days, my lord. My lord, if I may kindly complete, my lord.
We'll take up your matter at 3 p.m.
3 p.m.
3 p.m. Mr. Banerjee, let's express our mind. Prima facie, we have admitted the appeal, holding prima facie it is maintainable. Is that what we have done?
Yes, my lord.
Yes.
has not recorded maintainable, my lord.
Yes, prima facie. We have. Read the order. We have. An interim order was continuing. Since the prima facie case has been made out, according to us, we'll stay the operation of the order. In which case the suit will revive and your objection will not survive. That no interim protection can be granted without restoring the suit. This is only for a limited period and we'll hear out the appeal.
Yes,
Since the protection was continuing, in all fairness, you will be arguing your client's case on instruction, no doubt. But this is what we propose to do, Mr. Banerjee.
The only thing that I point out, my lord, subject to what falls from my lord, is that subject to the Order 7, Rule 11 being allowed, the suit being dismissed.
Yes.
Now, my lord, the recent judgment which went up from an Order 7, Rule 11 itself,
Yes,
my lord,
yes.
to the Supreme Court has held that since the plaint is not restored,
Yes.
the question of passing any interim order does not arise.
We are staying the opposition of the order, dismissing the suit or rejecting the plaint.
Then, my lord, kindly hears out the appeal itself.
We will. Today there's no time.
No, not today, my lord. Lordship has fixed it up on 18th. Lordship
Yes,
has
but
fixed it up on
there
18th.
before 18th, then don't take steps.
I have to take no steps. I am not there to take any steps.
My client is the one who will suffer, my lord. I'll make 1 minute submission. I'll leave it to you, lord.
Lordship, if I may kindly
We will, if we have fixed it on the 18th, Mr. Banerjee, since there was an interim order, we, in our opinion, that should continue for a limited period of
my
time.
lord.
This is what we propose to do at 3 o'clock.
Very well, my lord. Only thing is that in that case, my lord, allows me to, my lord, rely on the judgment and keeps it on record.
Yes, yes,
Because
we'll do that.
otherwise-
We'll do that. We'll do that.
I'm great.
My lord, if it-
Then come at 2:45 because we'll rise at 3:20.
Yes, yes, my lord. I can-
Come at 2:45.
Well, the original side matter, the good faith matter, well, there is no interim or nothing. Well, I think it was tagged down, and for that reason, it has been appearing today, OCD 1. that Millard, Mr. Uttaraman Bhattacharya was arguing Millard.
I see. Oh, I see.
You can keep it on 18. There is no scope, but this is only in this matter.
ওটা 18 তেই আছে।
না, আজকে appear আছে।
Let it be there where it is. Now you argue this matter.
Yes, I'm good. Lord, in this matter, as I showed, my lord, is that, my lord, the constitution of the bench was prior to even the amendment. And thereafter, my lord, there has been a reconstitution of the bench which has taken place post the amendment. My lord, I had shown from the document itself that, my lord, since the constitution of the bench is prior, therefore, my lord, a reconstitution is only with and very important, my lord, from the documents that my learned friend showed on the last day, my lord, the entirety of the, my lord, arbitrators were not changed.
To go to that point at all in view of what transpired.
That I have not shown to my learned friend. So
I requested, my lord, my learned senior friend, let me in.
Just now. So that is why I'm saying, my lord, apart from that, even because that point I'll, my lord, come and argue before my lord, is that, my lord, here the facts are little different. Lordship has to consider.
এবং বিপদে পড়ে গেছে এই পয়েন্টের বেনিফিট নিলে অন্য মামলায়
Not that.
I'm still in the dark.
Not that. There is a section 20.
The amending act of 2016 or 2015, as the case may be, 2015, has a section which says that nothing in the amending act will apply to an arbitration proceeding initiated in terms of section 21 of the Parent Act. Naturally before the Amendment Act.
It says, my lord, in terms of section 21, from the date that this act, amending act, is coming into effect.
That has been dealt with in a Supreme Court decision.
Yes.
Where it has been explained to what extent it will be prospective and to what extent it will be retrospective, even with, my lord, 12.5.
Which one? Which decision?
That is, my lord, the BCCI one. Bharat Broadband.
Not only Bharat Broadband.
No.
Subsequently, there is the other one.
Vishnu.
Perhaps not, because it's not Bharat Broadband. I'm not able to recollect the name, but it's some other judgment where this point has been explained, my lord. And I'll rely on that, because, my lord, 12.5 for, my lord, making it prospect. I'll have 3 dates, and those 3 dates will.
Have you read that section, Mr.
26, my lord, if I'm not wrong.
Of the amending act.
Of the amending act.
That we
It
can't
was in the
remember.
course of a judgment which I was reading, my lord. I've come across that. Yes, 26. 26.
Read out, just aloud. Read it aloud.
Nothing contained in this act shall apply to the arbitral proceedings commenced in accordance with the provisions of section 21 of the Principal Act before the commencement of this act, unless the parties otherwise agree, but this act shall apply in relation to arbitral proceedings commenced on or after the date of commencement of this act. This part has been explained, my lord. And there also, my lord, in that judgment, if I remember it correctly, there was a reconstitution post, my lord, 2015, and it was held that post 2015, if there's a reconstitution, then 12.5 would, my lord, mandatorily apply.
So that
I will come back with it. Kindly permit me any day, my lord, I'll come back with that.
It was fixed today, Mr. Bag.
Because I didn't know, my lord, this point will come up. But I was prepared on 3 dates, and that is what I was prepared to argue. Once, my lord, my learned friend would have made his submission.
You make your argument today.
One thing which I must point out, my lord, reconstitution has to be looked into in the facts of the case. Here, my lord, reconstitution is not the entire tribunal has gone away. Here, my lord, 1 or 2 of them have been replaced with the primary one staying there. So, my lord, reconstitution will date back to the date of the constitution under section 21, which I relied before, my lord. Because the reference starts from the date the, my lord, 21 notice is received, which I relied on the last.
Mr. Banerjee, these arguments are of no use. Whatever the Supreme Court has said, let us see.
My lord, I am
Let
arguing
us see.
just part of this matter.
26 point, again, this related. What he says, Supreme Court has said that if after the amending act has come into force,
Still then 12.5 will apply.
12.5 will apply. That is on the face of it, that's inconsistent with the section 26.
In fact, my lord, the Supreme Court view was this, that in a continuing arbitration, my lord, like this, which I'm going to show, my lord, the 26 will not apply. But in an arbitration which takes place, my lord, entirely.
Yes, sir. Is it the Ilora case you are talking about?
I think he is
I'm
talking
trying to
Ilora case.
Ilora.
trying to, my lord.
Because, my lord, there is a distinction made by the Supreme Court saying that in a continuing arbitration, although the award may be passed after amendment, this will not apply.
Hmm.
But if it is constituted post the amendment, it would apply.
Progress, I mean. Ilora.
Because this, my lord, if he says,
Lord,
it's
perhaps what is
contrary
falling
to
from your
BGPA.
lordship is Elora Paper Mills versus State of Madhya Pradesh 2022.
That's the Ilora concept, my lord, which
That's
has
the
which carved out by the Supreme
But there's a subsequent Sri Vishnu.
My lord, that lordship had given me yesterday. I'll consider that.
I should consider that and come back and make submissions. I should not, my lord.
Ilora,
Otherwise,
it's been considered in Sri Vishnu to that extent. I hope it's not like BGS Soma and the other one, my lord, not taking care of Balco. And
No,
saying that-
you'll also have to see the bench strength.
Yes, exactly. That's what I was on. That is why I referred to BGS Soma. It considers Balco. Then it does not say, my lord, that the bench strength there is a constitution bench saying that two courts will have jurisdiction. He should have referred it to a larger bench. But I'm not on that. I'm saying, my lord, in this case, reconstitution is what, my lord, has to be looked into. Because reconstitution does not mean, my lord, that it starts from that day. Even if we go by the, my lord,
Anyway, he says he'll come back after considering you place whatever you want to place to.
To show, my lord, that only, which my learned friend has relied upon on that day. Is that, my lord?
Shri Vishnu is 2023 8 SCC 329.
My lord, he relied on a page before.
Exactly.
My lord, I had shown, if your lordship remembers, my lord, is that, my lord, page 18.
Yes.
My lord, I had shown page 18, their own averments.
Page 80.
181.
18.
Kindly sees, my lord.
ये now to got that. Yes.
But kindly sees their pleading. This is, my lord, paragraph 30. The learned arbitral tribunal has held sittings for 5 days as mentioned in the award. However, after the initial date, 4 subsequent substantive hearings took place. It is quite evident that the petitioner had to wait for the award for almost 8 years from the date of submission of its claim, which itself speaks for lackadaisical attitude and approach of the tribunal appointed by the railways. All the tribunal members were connected with Indian Railways and virtually disqualified of being so appointed as arbitrators in view of section 12.5 read with the 5th and the 7th schedule of the Act. This, my lord, kindly mark. However, though the original reference was prior to the amendment dated 23rd 10 2015, now, my lord, this is also the date where section 26 comes in. Because although, my lord, it's December, notified by the president, my lord, but the effect
With effect, yes.
from December, October 20, 2015. But the tribunal entered into reference. My lord, this, my lord, interpretation is contrary to section 21, which I read out, my lord. Entering of references from the date that I received the section 21 notice, my lord, not from when the tribunal feels, my lord, to hold the first meeting. So, my lord, admittedly, from his averments as well as, my lord, from the, my lord, documents, it is evident that this is pre-amendment, my lord. The constitution of the tribunal is pre-amendment. On 30/12/2016, my lord, this meeting is held after amendment, but my lord, that will not constitute an arbitral tribunal. Now, my lord, kindly, however, it is quite interesting to note that after the dissolution of the first tribunal, the reconstruction of the tribunal was made on 18/4/2016. Out of the members of the erstwhile tribunal, only one member, namely Sri P. Dhansana, was present in both the tribunals. Therefore, my lord, it is not a fresh tribunal which has been formed. It is the same tribunal wherein two are replaced. My lord, I give an example. Today, my lord, there is a tribunal of three. Two of them, my lord, for some reason, health reason, or expires and are replaced with the tribunal we constituted from that day, my lord, or from the day it was originally constituted. It's a reconstitution which takes place on that day or subsequent dates even, my lord. But the constitution of the tribunal would be on the date when the original tribunal was formed under section 21. Then, my lord, he cannot say even that I had to wait for 8 years, my lord, for the award, 9 years for the award.
Assume A, B, C are the three members. A and B are replaced. X, Y come in. So X, Y, C. Same, it's a reconstitution. Then tomorrow C is replaced by Z. What happens?
My lord, this is again substitution.
So therefore, reconstitution or new tribunal?
Not new tribunal, my lord. That is why the legislative intent under section 15, my lord, is, my lord, substitution. It is substitution. My lord, considers a, my lord, proceeding like this, my lord, is that, my lord, a constitution of the tribunal takes place pre-amendment. The arbitration is continuing. I file a section 14 before my lord. Lordship passes an order, section 14 read with 15, my lord, substitute the arbitrator. Will, my lord, that, my lord, have the effect of, my lord, 12.5? It cannot, my lord. Then, my lord, every other matter this would be done. This would open a floodgate then, my lord. I can come before the my lord with de facto, not de jure. My lord, law remains the same. De facto and say this, then it would change.
No, but as we said, in this case, you may succeed solely on section 21 read with 26 of the amending act, subject to what he says the Supreme Court has clarified prospective, which part will be prospective, which part will be.
As I remember, I'll do little research because of the other matter, my lord, is that Supreme Court says where the arbitration continues prior to the amendment will not come into effect. But if it is a constitution post-amendment, amendment will come into effect in an arbitration proceeding. And it distinguishes it with a court proceeding.
That makes complete sense.
Arbitration proceeding has been distinguished from court proceedings, pending due pre-amendment and post-amendment. And I am on that, my lord, that this is a situation where this is a pre-amendment situation. That is also there, my lord, in BCCI. BCCI also says the same. If I may just read that paragraph, my lord, if lordship permits me. Now, see the paragraph. But may I just, for all of us, my lord, hand over the BCCI judgment. Kindly, my lord, sees this. This would be relevant in both the matters, my lord.
When is that matter fixed?
That's fixed, my lord, on Thursday. But kindly takes paragraph 38 onwards, my lord, where the Honorable Supreme Court, my lord, considered these situations. In it, look at it. The page. But kindly sees. Well, kindly see the distinctions smaller drawn out from paragraph 38.
Yes.
Well, it kindly takes paragraph 36 because that deals with 26. Kindly takes paragraph 36. May I read, Malad? All the learned counsel have agreed that this court has found on reading of section 26 that the provision is indeed in two parts. The first part refers to Amendment Act not applying to certain proceedings, whereas the second part affirmatively applies the Amendment Act to certain proceedings. The question is, what exactly is contained in both parts? The two parts are separated by the word but, which also shows that the two parts are separate and distinct. However, such and such has argued that expression but means only that there is an emphatic repetition of the first part of section 26 in the second part of the said section. For this, he relied upon concise Oxford Dictionary on Current English, which state introducing emphatic repetition repeatedly wanted to see nobody but nobody. Quite obviously, the context of the word but in section 26 cannot bear the aforesaid meaning, but deserves only to separate the two distinct parts of section 26. What will be noticed so far as the first part is concerned, which states, nothing contained in this act shall apply to the arbitral proceedings commenced. Kindly mark this, my lord. That's where, my lord, this matter is all about. In accordance with the provisions of section 21 of the Principal Act, before the commencement of this act, unless parties otherwise agree, is that, now my lord, the court what it holds, the arbitral proceedings and their commencement is mentioned in context of section 21 of the Principal Act. The expression used is to and not in relation to. This is very important, my lord. And third is, parties may otherwise agree. So far as the second part of section 26 is concerned, namely the part which reads, but this act shall apply in relation to arbitral proceedings commenced on or after the date of commencement of this act, makes it clear that the expression in relation to is used, and the expression the arbitral proceedings in accordance with the provisions of section 21 of the Principal Act is conspicuous by its absence. So therefore, my lord, the distinction is drawn from a proceeding pending and a proceeding which comes into force post the amendment of section 26. And that is, my lord, based on the section 21 reference, because that is the starting point, my lord. Not, my lord, a reconstitution or, my lord, a substitution.
Section 9. Section 34.
Otherwise, my lord, it would open a floodgate. With all pending proceedings, my lord, pre-amendment would come into the, my lord, arena of this amendment of section 20. Thereafter, my lord, that the expression the arbitral proceedings refers to proceedings before an arbitral tribunal is clear from the reading of chapter 5 of the 1996 Act, which reads as follows: conduct of arbitral proceedings. The entire chapter consists of section 18 to 27 dealing with the conduct of arbitral proceedings before an arbitral tribunal. What is also important to notice is that these proceedings alone are referred to, the expression to, as contrasted with the expression in relation to, making this clear. Also, the reference of section 21 of the 1996 Act, which appears in chapter 5 and which speaks of the arbitral proceedings commencing on the date on which the request for a dispute to be referred to arbitration is received by the respondent. That's the starting point. Would also make it clear that it is these proceedings and no others that form the subject matter of the first part of section 26. Also, since the conduct of arbitral proceedings is largely procedural in nature, parties may otherwise agree and apply the Amendment Act to arbitral proceedings that have commenced before the Amendment Act came into force. In stark contrast to the first part of section 26 is the second part. where the Amendment Act is made applicable in relation to arbitral proceedings which commenced on or after the date of commencement of the Amendment Act. What is conspicuous by its absence in the second part is any reference to section 21 of the 96 Act. Whereas the first part refers only to arbitral proceedings before an arbitral tribunal, the second part refers to court proceedings in relation to arbitral proceedings, and it is the commencement of these court proceedings that is referred to in the second part of section 26, as the words in relation to arbitral proceedings in the second part are not controlled by the application of section 21 of the 1996. This is what I was saying, the difference between the two parts has been derived at. One is, my lord, the arbitral proceedings which deals with section 18 to 27, and the second part is the court proceeding, my lord. Because, my lord, the arbitral proceedings would be, my lord, considered in view of section 21 of the 1996 Act. And if that is prior to the amendment, then, my lord, 26 will not apply. Now, my lord, kindly see 39 also, paragraph 39.
Then 26 will not apply, or 12.5 will not apply.
12.5. I believe 26 first part will apply, not
That's
the second part. First part will apply, not the second part. And therefore, my lord, obviously 12.5 will not apply. Or kindly see 39, where it bifurcates, my lord, the section 26 part. Section 26, therefore, bifurcates proceedings, as has been stated above, with a great degree of clarity into two sets of proceedings: arbitral proceedings themselves and court proceedings in relation thereto. The reason why the first part of section 26 is couched in negative form is only to state that the Amendment Act will apply even to arbitral proceedings commenced before the amendment if parties otherwise agree. So my learned friend then has the huge task of showing before my lord that I agreed by a consent, my lord, document that, my lord, I agree for application of the amendment. That is not there. Now, my lord, kindly sees. If the first part of section 26 were couched in positive language, like the second part, it would have been necessary to add a proviso stating that the Amendment Act would apply even to arbitral proceedings commenced before the Amendment Act if the parties agree. Because second part was with court proceedings, my lord. Now, my lord, kindly sees. In either case, the intention of the legislature remains the same. The negative form conveying exactly what could have been stated positively with the necessary proviso. Obviously, the arbitral proceedings having been subsumed in the first part cannot reappear in the second part, and the expression in relation to arbitral proceedings would therefore apply to court proceedings which relate to the arbitral proceedings, because court proceedings are linked to the arbitral proceedings. They cannot be, my lord, in isolation. Because I have to file, my lord, a court proceeding, my lord, post, my lord, the reference being done would be, my lord, from the proceeding itself in relation to the arbitration proceeding. Now, my lord, kindly see, the scheme of section 26 is thus clear that the Amendment Act is prospective in nature and will apply to those arbitral proceedings that are commenced as understood by section 21 of the Principal Act on or after the Amendment Act, and to court proceedings which have commenced on or after the Amendment Act came into force. We now consider some of the submissions, and then, my lord, kindly see the thing. 44, my lord, kindly takes. The view of this submission, counsel, my lord, then 44 kindly takes, my lord. Equally, the suggested interpretation of Mr. Such and Such would not only do violence to the plain language of section 26. Oh, my lord, I was just thinking, you seeing the word violence, who is the, my lord, the person drafting the judgment. So I saw the first name, so I felt, my lord, it goes with his name, violence, and other words. In relation to that, as well as ignore the fact that section 21 of the 1996 Act, though mentioned in the first part, is conspicuous by its absence in the second part. According to Such and Such, the expression arbitral proceedings commence is the same in both parts, and therefore the commencement of arbitral proceedings under section 21 is the only thing to be looked at. This was exactly what was argued. But this, I find that Mr. Vishwanathan's submission was exactly what we are before, my lord. That, my lord, 26 will give an effect to all proceedings even prior. But that is what the distinction has been drawn by the Honorable Supreme Court, saying that no proceedings which is commenced under 21 cannot be, my lord, come into the foray of the, my lord, 26 amendment. And that is why I say, my lord, in this case, that, my lord, particularly in the facts of this case, when the constitution has taken place prior and two of the, my lord, honorable members have been changed, there, my lord, the effect would not allow him to, my lord, file a 12-5 or take that point any further. Even if, my lord, today, let us take, my lord, even if today in this case, my learned friend would have filed a section 14 before, my lord, without filing a section 16, saying, my lord, de jure, my lord, the law says that, my lord, they cannot continue. My lord, the court could not have passed an order, although the proceeding is post-amendment filed under 14, because of the appointment taking place, my lord, admittedly under section 21 prior to, my lord, the section 21 coming into effect, or section 26 coming into effect. That is the distinction drawn, my lord. Otherwise, my lord, this would open a floodgate. Because, my lord, this is reconstitution or substitution. This is not constitution of the, my lord, bench or the tribunal.
Yes.
Now, my lord, kindly apropos this, kindly takes one more paragraph, my lord, paragraph 58, my lord. Kindly takes paragraph after the submissions being considered.
Yes.
From a reading of section 26 as interpreted by us, it thus becomes clear that in all cases where the section 34 petition, because it gives examples of other petitions also, is filed after the commencement of the Amendment Act and an application for stay having been made under section 36 therein, will be governed by section 34 as amended and section 36 as substituted. But what is to happen to section 34 petitions that have been filed before the commencement of the Amendment Act, which were governed by the section 36 of the old Act? Would section 36 as substituted apply to such petitions? To answer this question, we have necessary to decide on what is meant by enforcement in section 36. On one hand, it has been argued that enforcement is nothing but execution, and on the other hand, it has been argued that enforcement and execution are different concepts, enforcement being substantive and execution being procedural in nature. At this stage, it is necessary to set out the scheme of the 1996 Act. An arbitral proceeding commences under section 21 unless otherwise agreed by the parties when a dispute arises between the parties for which a request for the dispute to be referred to arbitration is received by the respondent. The arbitral proceedings terminate under section 32(1) by the delivery of a final award, arbitral award, or by circumstances mentioned in 32 subsection 2. The mandate of the arbitral tribunal terminates with the termination of the arbitral proceeding, save and except for correction and interpretation of the award within the bounds of section 33, or making of an arbitral tribunal as to claims presented in proceedings but omitted from the award. Once this is over, in cases where an arbitral award is delivered, such award shall be final and binding on the parties and persons claiming under them under section 35 of the 1996 Act. Under section 36, both pre and post amendment, such award shall be enforced in accordance with the provisions of the Code of Civil Procedure 1908 in the same manner as if it were a decree of the court. It is clear that the scheme of the 1996 Act is materially different from the scheme of the 1940 Act. Under section 17 of the 1940 Act, once an award is delivered, the court had to pronounce judgment in accordance with the award, following which a decree would be drawn up, which would then be executable under CPC. Under section 36 of the 1996 Act, the court does not have to deliver judgment in terms of the award. Which
maybe back minute.
which is then followed by a decree, which is the formal expression of the adjudication between the parties. Under Section 36 of the 1996 Act, the award is deemed to be a decree and shall be enforced under under CPC as such. Now, my lord, kindly see 60. This brings us to the manner of enforcement of a decree under CPC. A decree is enforced under CPC only through the execution of the process. Also, Section 36 as amended refers to provisions of the CPC for grant of stay of money decree. This in turn has reference to Order 41, Rule 5 of the Code of Civil Procedure, which appears under the chapter heading stay of proceedings and of execution. This being so, it is clear Section 32 refers to execution of an award as if it were a decree attaching provisions of Section 21 and Order 41 Rule 5 of the Code of Civil Procedure, and therefore would be a provision dealing with execution of arbitral awards. This being the case, we need to refer some thereafter, my lord, judgments have been referred to, and my lord, the distinction of 36(2) post-amendment and pre-amendment has been set forth. But my lord, everything boils down to Section 21. So, my lord, this being so, in this facts of the case, my lord, as I showed, and from the document that he has relied upon, this matter 12.5 cannot be.
So it seems subject to what he says.
It shows another judgment, but this judgment is quite clear on the subject. If he 71.
Mr. Banerjee, come back on Monday. Finish it off. It's fresh in the mind.
As he shows some other judgment of the Supreme Court saying otherwise.
So we'll post it at 12:45. We won't give you much time. 12:45.
Yes, ma'am. Because I think, my lord, BCCI is quite clear with the distinction of court proceedings 21 and, my lord, arbitration proceedings held prior. My lord, I'm not reading it. Kindly considers paragraph 76 once of this judgment, which I think puts an end to all the, my lord, discussions or, my lord, any doubts that we have with regard to the Amendment Act coming into it. Paragraph 76 one. But the case, my lord, the line is very nice to read. Learned counsel for the appellants have painted a lurid picture of anomalies that could arise in the case of Amendment Act, were generally to be made retrospective in application. Since we have already held that the Amendment Act is only prospective in application, no such anomalies can possibly arise. So I think it puts an end to all doubts.
এই কোথায় অর্ডারের ফাইলটা দাও Mr. Banerjee, learned counsel representing the respondent, resumes his argument and concludes.
Yes.
Paragraph lists this matter once again on Sombare date thou, marked 12:45 p.m. for Mr. Bagh to make his submission in reply.
matter. My item is appellate said commercial act number 7.
I was for the appellant, he was for the respondent. Your lordship remember he had taken that
Yes, yes.
point of res judicata, 2 appeals. Your lord.
Yes.
Can I take it up on next Tuesday?
Tuesday.
Number 9.
And handing over lordships, copy to list of dates which was already handed over to the Ashwal bench, which is hearing the matter. But now, for your lordship's convenience, we have.
Who is for Digha Shankarpur?
Digha Shankarpur, Mr. Bihani is appearing.
Mr. Bihani. He will be coming, Lordship. Yes, I believe it's.
Yes.
She's there.
My lord, if your lordship goes to the list of dates, may I just, for the sake of brevity, my lord, bring you to the facts of the case. It's a very old matter with a checkered career, my lord. 2004, the Digha Shankarpur authority, they had invited the various bidders to, my lord, make a building for construction of stalls.
Mr. Kundu, allow us to just go through the judgment. That is what we do.
Very well. Your lordship.
I'm not sure.
কিন্তু এটা তো আমার তো খাজা হয়ে গেছে ইম্পিউন অর্ডারটা। ইম্পিউন অর্ডার অন্য কোথাও আছে নিশ্চয়ই। Impugned order is apart from being annexed to the memo.
It
Is
is
it
also there.
It's 395.
395.
देखिए এটা দাও তো।
Volume 2.
Where do we find the award?
What is that?
305, page 305. Okay, same volume.
There are two things, my lord. There is an interim award as also a final award. So your lordship may first go to the final award, thereafter your lordship will go to the interim award as well.
That is at page 305, but same volume.
Section 34 has set aside what?
Section 30.
Final award.
Yes, but they have paid the amount which was granted under the interim award.
15 lakh.
15 lakhs.
Yes, Mr. Kundu.
My lord, your lordship has been made aware of the facts, my lord, but not for. My lord, we are aggrieved in the section 37 application by the order of the learned district judge, no? District judge, wherein the learned court had set aside the award on the grounds, twofold grounds, my lord. Basically, the court came to a conclusion, and how in a section 34 he could have come to such a conclusion, that when the arbitrator had come to a finding with the help of expert evidence and opinion sought for, which was agreed by both the parties in course of the arbitration proceedings, that as to whether or not the subject B7 plot of land fell within the CRZ zone 500 meters or not, was the issue. And based on the finding of the expert, which was not objected to by Dega Sangapur authority, the learned arbitrator came to a conclusion that based on the report of the expert, the entire zone fell outside the area. So, Maharaj, it is a question of fact, a disputed question of fact, even though, Maharaj, it's a fact, question of fact, and the arbitrator relying on the report of the expert and the learned section 34 court based his opinion or final order on the basis of some documents, xeroscopies which was given after the entire evidence was made and relied on, which is not competent to do so. Now, my lord, your lordships goes to the facts in a nutshell. In 2015, 2005, 12 January 2005 onwards, we started the construction. The various terms and conditions of the agreements stipulated that my clients would have to undertake the entire job within a period of 2 years from the date of commencement. And thereafter, they would have to foot the bill up to 40% of the work done. And then only thereafter, they would be entitled to drop the running account bill, not before that. So they had to fund their entire progress up to 40% at their own cost. Now, my lord, we started work and with a huge area. 690 stalls were supposed to be built in the area of 7 acres, no?
7.5.
7.5 acres of land. That is a big thing. At that point of time, the Digha Shankarpur authority never came up with any grievance that this is within the coastal regulatory zone, or otherwise they are not taken permission from the Ministry of Environment, either Government of West Bengal or the Government of India. That was never the question. So, my lord, we can put our bids on the basis of good faith and on the basis of fact that the entire thing was taken care of by the, after all, the authority is the Digha Shankarpur authority, which is the owner of the land, State Government of India, State Government of West Bengal. So, my lord, any permission
Yes.
My lord, now, my lord, we start work. Then on March 5th, 2005, we are given a letter by which we are stated, it's stated that the work remains suspended for 2 reasons. The first reason is that there has been a that is your page, my lord. Your lordship, I'm calling, go through the letter. বার করো না ভাই, page 51. Page 51. বার করে বসে বসে তোর পাশের মাঝে
And page 44, before that, kindly looks at page 44.
In first is page 44,
44.
24th March.
Yes.
Then
Discrepancies.
So, my lord, if there is any discrepancy, it is the job of the Digha Shankarpur authority, not mine. Had the discrepancies not been found prior to the grant of the letter of intent, as also the work order, it was their job to find out discrepancies, if any, supposed to have been visiting the bed. And number 2, the authority did not.
page 53, cancel. Page
No,
53,
numberটা কি ছিল?
So, what is continuing or waiting? Moreover, it was found that the proper permission was not
Yes,
taken.
and then number 2 is proper permission was not granted by the Ministry of Environment. পাশে দাঁড়িয়ে থাক না আমার সঙ্গে। There are 2 things. But they call upon us to immediately suspend the work. Can you appreciate one thing? A huge area, piling work is being, I'm sorry. Can I continue, my lord? Number one, your lordship will really appreciate two things. A huge area, piling work is being sought to be done. Cement, plaster, boulders, iron, blood, all those other requirements, sand is being piled up for work being done on a regular basis, because I have to complete 690 salt within a period of 2 years. Now, my lord, 24th April, in April, we were given a letter calling upon us that you have not stopped work. And 23rd of February, March, the work was cancelled.
Mr. Biani, you may go because Mr. Kundu will take at least half an hour. At least.
More than.
We'll have to stop this matter around 3 o'clock or even before. We have fixed another matter and then we'll have to rise at 3:15.
But I was aware of that. Possible I can leave, possibly if it doesn't arc your lordships, because possible in the morning my submission was not proper.
Go.
I'm deeply obliged, your lordship. Deeply. Lordship will not take me amiss.
Lord, he is led with good hands in his absence.
That is personal.
No, why personal? Nothing is personal.
Yes.
No, my lord. So, my lord, let's see the letter of cancellation. Letter of cancellation.
The first volume to the
page 53.
Page 53. My lord, Junior would not. It's an only my lord. Read the letter, my lord.
Page 53. May I please? Page 53, may I please?
53. 53. You have read it.
My lord, your lordship will see. The first time your lordship will see the letter of cancellation. Firstly, doesn't speak of the allegation, the first allegation made in the earlier letter of suspension of the work, that there were some discrepancies in the work order. It is not, it's absolutely silent about that. The only ground is that permission,
non-availability of permission,
was not taken from the appropriate authorities. I may ask the question to myself, my lord. If any permission was required to be taken from any authority, it was not the job of the contractor. Certainly not. Rather, Shankapur Jiga authority, they in their affidavit in opposition say that the authority, the contractor who was supposed to take the permission. The agreement nowhere states either the requirement was there to be taken from the authority concerned, then in that event, the obligation would be squarely falling on me. Number two, my lord, in any event of the matter, the Shankapur authority never, in their wildest imagination, came to any finding prior to the grant of the letter of intent in my favor that there may be a possibility in the near future that the Ministry of Environment may come and stop the work. That was not the authority. And in any event of the matter, the obligation was on the employer. Your lordship wanted to say very interesting thing thereafter. They cancel, and then after 7 days, in the same cell area, B7, they invite another tender. A second tender after cancelling mine, without taking any permission from the Ministry of Environment. We told that was the reason.
সেকেন্ড প্যারাগ্রাফটাতে দেখিয়ে দাও সেকেন্ড প্যারাগ্রাফ যেখানে বললো
Ultimately, that construction came up.
Partly it came up, and that was the basis on which the interim award was passed, because the court, the arbitrator, because one of our claims before the arbitrator was the work which we had already done. We should be reimbursed with that.
No, we understand. We are asking, was the project completed?
No.
But they again advertised second time.
Second time they may advertise. The second advertisement was also given a go by, and as of today,
vacant for us.
As of today, it's lying vacant. As of today, it's lying vacant.
Yeah, our construction is lying there.
Huh?
Still. That part construction is lying.
On the power part construction is lying there. Now, my lord, they cancel my thing. I make a prayer. I make a representation. Please reimburse me all the cost expenses which I've already incurred. They don't, obviously, they do not make any payment. Then they ask us that they have a joint measurement of the work which we have done. A joint measurement is taken, and that comes to rupees 16.5 lakhs. On the basis whereof an interim award was passed by the London arbitrator, and they paid the money within time, as was directed by the London arbitrator in the interim award.
Did I have any occasion to deal with this matter before? Either singly or sitting in division? Facts sound very...
Singly, it was before the decision. Singly, it was before the decision.
Admission was Justice Shen.
Oh,
division bench.
I think Justice Shen was the...
Was admitted. Yes, appeal was admitted by...
Appeal was admitted before the...
And thereafter, subsequently heard also by this division.
In fact, my dear lordship, we'll go through the various orders passed by the division bench. It is all Justice Shen order. The bench presided by Justice Shen. In fact, Justice Shen and the division bench presided by the elaborately had the matter not, but thereafter his lordship has not keen to continue with the matter by the change of determination. Yes. Now, my lord, I don't know whether your lordship may have done some other similar sort of matter in your lordship must have dealt with some other matter, but this is not the matter in which your lordship was called upon to hear it. Now, my lord, after my issuance of Section 21 notices, Justice Somaresh Banerjee, late Justice Somaresh Banerjee was appointed as an arbitrator, and thereafter his lordship, after going through all the claims and counterclaims, came up with a final award. In the final award, out of the 13 claims which was made by the petitioner's appellant before your lordships, his lordship was pleased to give only 5 of the claims, two parts. So 7 claims were outrightly rejected by his lordship. And the basis on which his lordship was pleased to grant the claim was, number 1, that certain job work was done which was measured without any objection made by the Digha Chongopur authority, and on that basis his lordship was pleased to grant a part word award. And a few other orders, Lord, which is Lordship was pleased to a few other issues in which your Lordship was pleased, but the majority of the award hinges around a sum of rupees 71 lakhs, 71 lakhs, no, 71 lakhs and odd, based on section 73 and 74 of the Contempt Act. And his Lordship, your Lordship must have seen in the award, his Lordship was pleased to rely on the judgment of the Supreme Court, Lord, in 80 Beachpal Singh's case. 15%. 15%. Now,
Yes.
one thing which weighed with the learned arbitrator was that having cancelled for whatever reason, right, gone in different, whatever reasons, the tender, in fact, the work order, rather, and the memorandum of agreement also. And thereafter, within a period of 7 days, in the self-same area, for the self-same job, the authority was another tender. And the best part of it is was that we again participated in that, the appellant to your lordships. And then your lordship, I will not be very candid thereafter what happened. Seeing our name that we are also the applicants, I think we were not favored with the second time. And that was what was traveling the earlier bench also. As to how could the authorities say on one hand that there is requirement of getting the CRZ clearance from the ministry, whilst at the same time you call a second tender on the self-same ground without even adverting to the fact that there is a requirement of clearance of the CRZ area. Number two, thereafter, my lordship will see the award which was granted, which was published by the learned arbitrator, highlights two things. One, my lord, that the expert who was appointed, your lordship will see who the expert was. I'll just bring to your lordship's convert expert.
245.
Page 245.
Page 245.
Page 245. He was at that point of time the number one environmental person in the state of West Bengal. And his name was suggested by the Sangapur authority themselves. And we had accepted to that.
चलो बेटा देखिए 242
245
245
yes
report about
report.
This is the report. So you will see everything is there in the map as well. For map Prabhakar.
$251 is the map.
Page 251 as well.
The disputed structure falls outside the coastal zone provision.
See, the disputed structure falls outside the coastal regulatory zone area.
And this was in color also. He has shown it in color, but we don't have a copy. That's from the original records. Sure. The gadgets he has used. Was also checked and verified by the senior factist Institute of Environmental Studies.
So as you will see the report at the bottom, it has been further vetted by the senior scientists of the government of West Bengal. At the bottom, so as you will see.
Page 51.
Page 51. Arbitration একটা বার করো।
হ্যাঁ
Arbitration একটা বার করো।
হ্যাঁ Section 26.
So Kundu, when will you come back? We have to stop because we have fixed a matter.
Tuesday morning.
Can I make one prayer for your lordships? Normally your lordships takes up on Tuesdays and Thursdays. But this Tuesday, Manad, I have got a matter fixed before the Honorable Chief Justice.
That's at
2 o'clock. Could your lordships give me some indulgence in the first half on Tuesday?
10:30 or
We can give you. How long will you take?
I'll take around half an hour. Maybe
Half an hour. কটায় ফিক্সড আছে 11:45 লেখো অভিজিৎ Mr. Kundu, learned senior counsel representing the appellant in this appeal under section 37 of the Arbitration and Conciliation Act, 1996, begins his argument but does not conclude. Paragraph on Mr. Kundu's request, let this matter be listed again on Mongolware date thou marked 11:45 a.m. Just show us that case, Mr. Banerjee.
The similar situation, my lord, wherein a dismissal has been made under Order 7, Rule 11 only. And now, my lord, I am even happy to come back on 18 Because now I have a judgment of my lord sitting in division bench holding that it is not maintainable.
What is not maintainable?
My lord's judgment.
What is not maintainable?
The appeal is not maintainable. এটা কপি দাও, এটা কপি দাও, ওইটার একটা কপি দাও, এটার একটা কপি দাও, এটার কপি। So now I'm very happy to come back on 18th.
We will come back till then. Let them enjoy.
This, my lord, is a similar situation wherein an appeal and an application was filed under Order 7, Rule 11, my lord, that was dismissed. My lord, kindly see is paragraph 5. Having heard the learned counsel for the appellant and learned senior counsel for the respondent, we observe that in a case where an appeal is filed by being aggrieved by the rejection of a plaintiff in exercise of powers under Order 7, Rule 11, the High Court ought not to have granted an order of temporary injunction. We say so for the reason that the plaintiff itself has been rejected by the commercial court, and the correctness or otherwise of the said rejection is a matter at large before the High Court. When the plaintiff itself has been rejected, it cannot be said that the appeal filed against such an order is a continuation of the suit. It may be that in the commercial suit, the respondent herein had the benefit of an interim injunction. But once the plaintiff has been rejected by the trial court,
Order which pass করেনি। Eighteenth is Monday.
Monday.
What we'll do, Mr. Banerjee, we'll continue the order to the 20th. Till the 20th. We'll refer to this
in the manner that Lordship has passed.
Yes. Are you opposing what we propose to do, or are you supporting?
My instructions, I leave it to your lordship. My instructions are to oppose.
Very well.
But may I only indicate page 4 of the order,
Yes.
second last paragraph.
Yes.
That there was a direction that in the meantime, on paying stated monthly installment for an assistant.
Who is the respondent number 1?
I am the respondent number 1.
Asad. And respondent number 3 is Asad. This has not been complied with yet.
Why the contempt? Why?
It's not being paid from June. That's the difficulty that you're facing.
We are deciding finally within a few days. এসো তো।
দেখিয়ে দিবি তোর ব্যাংক স্টেটমেন্ট, তাহলে তো হলো।
Read order dated July 29, 2025. Stop. Paragraph. By that order, we had admitted this appeal without prejudice to the contentions of the respondents as regards the maintainability of the appeal. Stop. We had also directed that the order dated May 1, 2025, by which we had disposed of AOCOM 5 of 2025 and AOCOM 7 of 2025, should continue for a period of 10 days or until further order, whichever is earlier. We had clarified that the respondent number 1 shall go on paying equated monthly installments to the respondent number 3 in terms of the order dated July 29, 2025. In terms of that order read with the order dated May 1, 2025. Stop. Paragraph. A prayer is made on behalf of the appellant for extension of the interim order. Stop. Such prayer is opposed by the respondents. Paragraph. Mr. Banerjee, learned counsel appearing for the respondent number 1 cites the decision of the Honorable Supreme Court in the case of SLP number from rendered on May 27, 2025. Stop. No, 25, in support of his contention that without restoring the suit/plaint, no interim order can be passed in the appeal. Stop. Paragraph. Mr. Banerjee may be right, since the plaint stands rejected by the order under appeal. Stop. Hence, as such, the appeal cannot be said to be a continuation of the suit. Stop. Paragraph. We, however, find that an arguable case has been made out by the appellant. Stop. In view of such prima facie arguable case, we stay the operation of the order under appeal for a limited period. Stop. We have fixed the appeal for hearing on August 18, 2025. Stop. The order under appeal shall remain stayed till August 20, 2025. Stop.
Order.
The interim order that we had passed on July 29, 2025 shall stand reinstated and shall continue till August 20, 2025, or until further order, whichever is earlier.
Only prayer is that, my lordship, the last order which lordship has recorded, that lordship wants to hear out the matter, and therefore my lordship is passing an order till my lord 10 for 10 days. That, my lord, if it extended would be rather, my lord, proper, because if lordship stays the order in appeal, then my lord, the plaint gets revived.
Correct.
So then, my lord, in that case, lordship is not hearing. Lordship has said that to stay this order till 10 days, because lordship wants to prima facie hear out the arguable case.
Unless we stay the operation of the order and revive the plaint for the time being, how do we pass an interim
So
order?
that is, my lord, an understanding that we can, my lord, we can from the bar give, because if, my lord, the plaint is revived, then the question lordship is deciding prima facie at least that, my lord, the appeal is maintainable. Then, my lord, we would be, my lord, prejudiced, my lord.
No, why? This is all prima facie.
No, my lord,
These are going to have
kindly see,
no here.
this order was not, my lord, having that amount of, my lord, pressure on us, because lordship has, my lord, recorded that there is an amicus and lordship wants to hear out the point of view.
Yes.
That is, my lord, nobody is prejudiced to that extent, except, my lord, this, I must point out this order of the Supreme Court. But, my lord, this order, that lordship is saying
Then,
that the order
if we can just
extend this order till, my lord, 20th, there is no issue.
no, then we can't take. Once we have cited this, we can't do it. Once we have
Lordship
cited
extends
this,
it. We are not, my lord.
no,
we
we can at best record your assurance.
I am nothing to do in this.
All the respondents,
I have nothing to do in this.
all the respondents' assurance that till 20th, nothing, they will do nothing. Therefore, you see.
Then, my lord, I don't know about him, but, my lord, in that case, I am prejudiced because the plaint gets revived, because lordship is following the principle, my lord. Then the appeal has to be heard, my lord.
Yes, appeal has to be heard.
Then, if your lordship today, my lord, revives the order under appeal, kindly, my lord, considers, my lord, then, my lord, as a respondent, the plaint, my lord, is revived. Although lordship is holding
what
that,
happens?
No, although lordship is holding that, my lord, there is a substance in this matter which requires to be heard out on the law point. And, my lord, today, my lord, I can show, my lord, that this is not appealable. So therefore, my lord, if it is prima facie, my lord, then the order, my lord, is
Mr. Banerjee,
modified.
we have again referring to
Kindly considers this extension of this order till 20th. This, my lord, I think kindly, this portion is the best that Lordship has recorded. Since
how can we?
No, my lord, this portion, since the appellant plaintiff was enjoying that order for quite some time, we are of the view that the order should be operated for another 10 days. This can be extended. I'm
In
saying,
what
my lord,
proceeding?
in the appeal which is pending before my lord. In the appeal which is pending before my lord, in view of the findings,
Supreme Court has said without restoring the suit or the plaintiff.
that is the my lord position. So if Lordship is reviving the plaint, then my
Prima
lord,
facie without prejudice everything.
but that would prejudice my clients because the plaint gets revived without the hearing taking place of the issue of law that Lordship we have raised before my lord. My prima
Exactly,
facie,
we are not following. What will happen if on the 18th we accept your contention? Goes, appeal goes, everything goes. This is only an interim measure, including the revival of the plaint. On 18th, everything might go. If you say there's a judgment of the division bench by which we are bound, we are bound.
that is something Lordship will hear out and then my lord
What
pass
we
an
are
order.
saying, if we accept your contention, everything will go. So how you are prejudiced, we really don't understand.
Because my lord, the plaint today, my lord, by this order, the
Let
plaint
us
is
assume it
revised.
revives till the 20th. On the 18th, we accept your contention, plaint goes.
Very well, my lord. We'll
That's
come back.
right. We don't see any real prejudice. কি হলো কি সব গেল গুলিয়ে
No, no. The order is already dictated, my lord.
Stand reinstated and shall continue till August 2025.
or until further order, whichever is earlier. Paragraph lists the matter on August 18 as directed earlier. Now August 18 কোথায় direction
My
আছে?
lord,
আছে তো? আছে তো? ঠিক আছে।
but can it be at 3 o'clock, my lord, since this will take some time now?
করে দাও 3 o'clock.
Because I'm sure, my lord,
3 o'clock.
all of us would try
3
to.
o'clock, 3 o'clock.
I'm so
But
grateful.
please be absolutely brief. Just it's a point of law.
Yes, my lord, yes, of course.
In fact, I'll not have any position to make. It's a fight between the plaintiff and the defendant. I'm not even a party in the main suit. But it's a growing SSO which is not pending adjudication.
You are a party in the appeal.
We have been a party in the appeal. That's because we have an
You don't want to be. We'll strike out your name.
The only difficulty is that I will not have enough because my point is very different. I indicate that.
No, he is not, my lord, challenging.
Mr. Bagh, if Mr. Banerjee persuades us that this appeal is not maintainable, end of the matter there,
He
this
also
appeal goes.
gets the same benefit. Grateful.
Then please also come prepared to distinguish, or I don't know how to deal with Srishti.
But I will distinguish on the face of it. It does not deal with the issue in question. And my lord, the same honorable court has passed 3 other judgments saying that 4 other judgments, correct, my lord, that my lord, the appeal is not maintainable. Same division bench. And I'll show my lord's division bench. So Supreme Court, that my lord, it is not maintainable. Apart from Chennai High Court also.
Make a bunch
Yes, yes.
with an index.
Yes. It's per inquirum. I'll show that judgment is per inquirum. I'll show. Great.
Lordship, in that case, if my learned senior friend can give us.
Nowadays,
Because these are legal submissions. my
yes,
lordship.
yes, we'll come
So,
prepared.
I cannot
What
run.
do you mean legal submission? How can he make an illegal submission?
Lordship, then I'll be prepared, my lord.
I think he's prepared in the. He can.
That is between you and Mr. Banerjee. আমাদের ডাকো ভাই উঠে যাই।
Because even on the last occasion, he shied away. I'm grateful, my lord.
I only submitted. I apologize for not being present, my lord. In the morning, I was on legs when that matter was called twice.
Which one? Which one?
So this is that point, my lord, Section 9, Arbitration Act and Territorial Jurisdiction.
What have we done? Dismissed it?
No, my lord. It was made not today. Tomorrow, I'm in some difficulty, my lord. I may not be here.
Appellate side?
It's appellate side.
Tomorrow, no chance.
Not come, but
No chance, no chance.
we found an answer to the query which has been raised, but I was not in a position to answer on the last day. I have found something and argument.
All right.
Deeply obliged.
I'm grateful.